Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Green buzz lights up the air, faces tense as stories tear, truth and lies like a tangled dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes stand, shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello, good morning, everybody. Sorry, I had my thing muted. So, 11:20. Sorry, Denise, I was just looking. So, 11:20. That will be in an hour and 20 minutes. So that will be about 3:20. Right. Okay. Sorry. Because good morning, everybody. Good morning, Zio, Denise, Willow, Paula, Lois. Good morning, everybody. Wow, everyone is here, and it is Tuesday. Sorry, I forgot which day it was for a second. Today is Tuesday. We have a very big day long ahead of us. I am my apologies. I wanted to start to say I am sorry because I was supposed to go live about an hour ago, and I got because this time change that you guys had this past weekend, we haven't, so we are closer in time. That means that my time between I finish work and the live streams that I set up for 9 a.m. Eastern, it's a lot closer together. And I forgot about that. And I forgot I had to do a couple of bits before stream today, like researching some stuff for court and cases that we are following and things that are happening. And I forgot that I also had to eat and maybe just like have a bit of a shut eye before. So I just needed that time. And when I finally sat down and I was like, oh, okay, I need some food, it was way too close of 1 o'clock for me, 9 o'clock for you, so for you guys. And then I saw that there was nothing really going on. So I was like, okay, all right, I can maybe postpone an hour if everyone is okay with that. So I can give you a bit of more time as well to wake up and to have your coffees, teas, whatever drink you have in the morning, and then actually start today because today we have a lot going on. I know everyone is active and here today. That is amazing. I love seeing everybody. It is great. I think everyone is pumped today. I am very. There's a lot going on, and I might miss some of it because in about 2 hours and 40 minutes, I'm gonna have to leave for a doctor's appointment, but Nightbot, a garden bot, is gonna stay with you. Um, oh, Ghost Adventures, no. Is it something that we should be watching, Willow? Because that seems interesting. Oh. No. Oh, what? It was a hitman. Ooh, wow. Right, that is crazy, Willow. So Gardenbot is gonna replace me while I need to go to my doctor's appointment. It's not nothing big deal. It's just my eczema has been flaring up. No. Well, the hour is up, Lois. I thought, you had an hour, but that hour is up. So, uh, sorry, distracted by chat as always. So gonna go for my doctor's appointment, but at the same time that I have my doctor's appointment, our friend, she's not a friend, but it's like the next trial that we are gonna be covering, Lori Valo Daybell, or whatever she wants to be called that. Oh, good, I missed you too, Toxic. I hope you were okay. Which also, all the information, all I want to say documents. I haven't seen if the. I think I'm hoping I am saying correct. We have documents. We have. Oh, Willow, send me that link. And yeah. Oh, we go to that to X. Definitely check Willow's X on that one. But I was gonna talk about the Discord. Cause everything that I know about Lori Day Vallow, or follow Daybell or whatever you want to call it, because I never get. We have it on Discord, which also we can talk there about this case, because it is going to be wild and it's going to be hot and it's going to be very good. So we can always check Discord for all that good, awesome information that they have there. They're a great bunch of people because I'm there. No, I'm joking. I'm joking. That was a very bad joke. So that is going to be our next trial. So she has a hearing today, which is, I think, by what Denise was saying, at 8:20 PT, which is about 2 hours time. So, which is in about 2 hours for me as well, which will be at the time of my doctor's appointment. But don't worry, GardenBot will be with you to check that hearing as well. So that is absolutely amazing. So, we're gonna see that in about 2 hours. But also in about 2 hours, we're gonna have our closings and our verdict watch on our trial of the Stacy Rodriguez. I did an addition for that because obviously right now we are just hanging out and gonna probably watch some parole hearings or something, or just talk about life and things, because I know you love to hear me talking. No, I'm joking, and no one wants that. So we're gonna just this, and then I did a separate stream which I will redirect everybody to it just before court starts, because my idea is between now I need to think about time zones. Between 11 no, between 1 and 2 p.m. Eastern. Okay, I'm going to be talking Eastern. Between 1 p.m. Eastern and 2 p.m. Eastern, I am going to be taking like an hour lunch break. So then I can redirect you guys for the new stream. So hopefully, if the hearing of the Lori Daybell, Valo Daybell thing doesn't finish or doesn't start just before that, we might cover her hearing while we're on verdict watch, if that makes sense. Because I don't know specifically the time for this hearing, and my brain is all muddled up with time zones right now, because after the time changes, I'm still not 100% there. Well, I never was 100% there. So, yeah. Hang on, sorry, my phone is absolutely... Hang on. Sorry, my phone is absolutely going crazy with work. What do you mean, GardenBot? You there?
I've never been there.
Oh, I have never been there. Where haven't I ever been? Sorry. What? Oh, in my head, yes, I was never. See, this is okay. I have to be very, very upfront with something. I may have had or not. Probably you guys will say that I have, and I have. I've had an energy drink today, plus 4 coffees. So I've had a Red Bull, and it was a very big Red Bull. It was a 473 milliliters, like almost half a liter of a Red Bull, which probably doesn't help. And 4 coffees. So, because, the thing that I was exhausted this morning. And I was saying, I am going to have a very long day ahead of me. I'm probably not going to have time for a nap. And, yeah, I had to have. It's not that I had to, but I felt the need of. So, if I'm talking too fast or if I'm too electric or anything, please tell me to calm down. Because I need it, because otherwise I will get way too enthusiastic, way too loud, and you all leave. No, I'm joking. Sorry, and I should not have had that Red Bull. I now regret my decisions. It did help me do my work and get things on time, but yeah. Oh, that's the thing, right? For me, I need energy drinks. When I do, in a very rare occasion, I don't have energy drinks all the time. I have one in a blue moon, very, very rare, because I actually forbidden energy drinks in our house because me and Garden Bot, we at the beginning of our marriage, we had a very bad habit of drinking energy drinks like it was water. You still work. Well, I can help you work on the second and the third. And, no, I'm joking. We've banned energy drinks because we were drinking too much, and they are, in my opinion, they are not very good for your health. But in a very rare occasion, we allowed to have to have one if we actually need it, and not just because we want it, because I don't yeah, exactly, like very rare occasions like this, and you are recovering as well, so we need, and they are there for that. It's not, in my opinion, it's not something to have irregularly. Oh, hello, good morning, ADK, welcome in. How are you? I haven't seen you in ages. I Courts and trials at different times. Darling, how are you today? I hope you are well. Happy Tuesday. We're just having a bit of a hangout before our closings and verdict watch of the trial we've been covering. It's been a very spicy trial. Look at the counter of objections we have. So, absolutely crazy. It's been almost 300 objections in this 8-day trial that has been. We still have closings to go through, which I'm sure we're gonna have um some objections throughout, so we still gonna probably hit 300 for sure. But now we're just like chit-chatting a bit. We might listen to some parole hearings that we love to do in this channel, and then we're gonna try to cover something else as well, but we'll see in which stream we'll be doing, because for once I'm actually doing 2 streams in the same day, which is a very rare occasion for me. Because normally I like to do everything in one go and not break, but because of circumstances of the other court, it does takes that. Thank you very much, DK. I really like your support, girl. Thank you very much. Much love to you, and really, really appreciate that. Also, Paula, I have something for you. So, you know that you asked me about the sentencing of that guy that the judge in our current case has this morning in the court in well, let me see, in about 2 hours time. I was able to find some information because of what he said yesterday. It did prick me my attention as well, and also because you were saying it was a very sad case. It's going to be having a lot of people talking. I did some digging, and I found 3 sentencings at 10 a.m. in Weld County in Colorado. And I did some investigations, and there's 2 ones that I couldn't find that much information. So I think it's, and they were saying the charges on the inmate search for that county, that is like how am I gonna say, narcotics enthusiastics, like Kathy says, narcotics enthusiastic charges. So I don't think those ones are gonna be as well. It is sad, but it's not gonna be as sad as the judge let it be. But I found another case that the guy is called Scott Mckee, is on a $50,000 bond, and his charges are bond revocation, careless driving causing death, and leaving the scene of an accident involving unaliving. So I think, in my opinion, that is the case that the judge was talking about. And another great thing is, I found, and I found it previously as well, that the Weld County has a WebEx live streaming services that they normally stream cases and everything. So I'm hoping that at that time that it is the sentencing, we're gonna be able to look at, to see. It is in about an hour and 45 minutes though. So it's yeah, so because you did ask me to do some investigation and I listened and I did it, because sometimes that's what like I was doing in that like extra hour that I had to ask you guys to be able to have, was to do that kind of investigation that you had asked me, because I could have done last night, you are right, but I was so tired last night, that I just had, I needed to go to bed early, and we did went to bed early, and we had a good rest, but probably was not enough for today. Um, in terms of actually, I'm thinking, right, and this is me thinking that we're gonna get a verdict today. I don't think this is the case, or the fire case of the Stacey Rodriguez case. It's not a case that we are gonna have a 2-day deliberation. In my opinion, I don't think it is. I think we are gonna be done and dusted today. I don't know if we have a new trial yet in line. So what I was thinking is, and it sounds pretty wild, I know. Sounds very, very wild what I'm about to say. But if we don't have a new trial, or a new trial doesn't pop in tomorrow out of, well, thin air, or that is the feed for it, I might actually have the day off tomorrow. But this is just if we don't have any case. If there is a case, if there is a case, obviously we'll definitely jump into it. Or if you guys have a case that you would like me to follow, um Denise, I am kinda rooting to be done today, because I would love a day off. Because, well, I have a day off from streaming, but I have loads to work. I need to work on the spreadsheet for you guys. I haven't forgotten. I will send it, but I'm just waiting on this case to be done, right? So I can update it, the spreadsheet, and then I can share it with you guys, the most updated version. Because the thing is, if I'm sharing it now, you guys can update it yourself, but I wanted to send the most updated, so I'm just waiting on this case to be done, and then I can update the spreadsheet as we go. So that's what's happening with the spreadsheet, but I want to update it, and there's a lot of information that I need to investigate for this spreadsheet as well. And then we can update it. And there's also the Lucy Letby case that I want to carry on digging, that we are doing. And there's another commitment that I have to get done as well by the end of the month. So there is a lot of things going on in the background. I might have a day off from streaming, but I have a lot of admin work to do and everything. But if there is a new case, definitely we're gonna be jumping on there. That is absolutely guaranteed. But we'll see what happens. See what is on the schedule. I know that we are gonna be covering the Laurie Daybell trial whenever it comes to it. I still need to figure it out, time zones, because you guys saying that they don't change time zones, but we do. UK does. Just before the head trial starts, it literally messed my head off yesterday. I was looking at time zones, and I still am, because this during 2 weeks on the year, because this happens at the end of the year as well. So when you guys go back in time, back in time, on fall back, we only go fall back 2 weeks after you guys. Always. This is always the case. Every year is the same. This is the first year that I am dealing with time zones while streaming and everything. So my head is a little bit confused, to say the least. So I am trying to figure that out and actually know what am I doing. So, but we're gonna be covering, no matter what. It's just me figuring out what am I doing in terms of work, and in terms of asking Gardenbot to do it or not. But yeah, we'll figure it out. I have Stephanie, but yeah, exactly. It's the thing is, I have a website that CEO, a good friend of mine, shared with me, and I used it all the time. But it's just the thinking, because Arizona doesn't change, and I keep thinking that they do. It's just like I need to put in my head, and I need to study it, but I need time for that. So, yes, time change should be in order by March 31st. Yes, it starts there, the jury selection. So it's just me figuring it out, the times between, because I keep thinking that we are going to be jumping ahead to, or are we going to fall back? I don't know. I keep forgetting. And then I keep creating a confusion in my head and make it as a bigger thing than it actually is. So, oh yeah, I know she is amazing. She's great. So I do have that, and I really appreciate that. But it's just sometimes I'm looking at that like I'm looking at let me see, a law book that I have that I'm reading from American law. It's like, huh? No, no comprendo. So it's just my head has to go around. So yeah, exactly, isn't it? As soon as I have figured it out, they're gonna change it again. So oh no, please don't, Paula. Like, if that is gonna be absolutely wild. If you guys change again or not change it, well, if you not change anymore, that would be perfect, because then I would always know. But until I figure that out, would it be, oh. Because then the thing is, right? I was searching, and correct me if I'm wrong, does Arizona has more than one time zone? Is it one of the states like Florida that I did not know? But I found that out that because of the trial we covered at the beginning of the year, the Zachary Young one, of the CNN guy, he apparently Florida does has two time zones as well, and I did not know that, and I was very, yeah. See, no, yes. Oh my days. See, now we got conflict. So it's just like, and then it's the fact that the same state has two different time zones. So it depends on the county that we are following. It depends on the time. And that makes my head confusing. So it's just crazy. And I need to study that. Maybe we could do a stream of studying the time zones. No, I'm joking. That was a joke. We're not gonna do that. Yeah, it is. It is very hard to keep track this. And it's because then you guys have like a lot of time zones and a lot of changings. So, oh, oh. So the thing is with the mountain standard, and then, oh, oh my days, you guys are even confusing me now. So technically, yes or no. That is not like zero. No, I'm joking. It's like I would be like the judge, ma'am. Yes or no? Not technically yes, technically. No, I'm joking. Oh, okay. Because of the panhandle. Okay, I need to see. I think I need to study American geography and time zones, and I actually understand that. Because I think that will be very helpful for the channel. The thing is, I am normally not confused about these things, but it's just crazy because with the changes, because I was fine last week. Last week I was okay. I knew the time. I was fine. We were grooving, and then y'all came up and change everything. So, so it's just absolutely crazy. But I'll be fine. We'll figure it out. That's the main thing. We'll figure it out at some point. And and then when I figured it out, the time zones, guess what's gonna happen? They're gonna change it again. Because we are gonna change our time in 2 weeks. So that is gonna be awesome. Um which is gonna be good because I'm not complaining, because I mean we're gonna have more daylight and I'm gonna be able to see sunrises on my way to work, which is gonna be amazing, and I'm really looking forward to that. I am just not looking forward to the fact that I'm losing an hour of sleep, and my head is gonna go up in confusion again, because of the time zones. Um, Oh, okay. Thank you very much, Denise. Like, see, people are sending me information. I need to study. If you guys know of a great place apart from you, Wikipedia, to learn about time zones, please share with me. I would love to learn a bit more. I know it sounds a bit of a geek, but I feel like it's very important for me, especially because of what I'm doing right now with like hanging out with you guys. I want to, and also because I want to make sure of how which like streams am I covering, which trials am I covering, because sometimes I've just jump into a trial not really knowing where is it, and then I'm like, oh, it's a little bit out of my time zone, so do you know what I mean? So it's just to make sure that I'm doing things correctly for once, and not like then having to Gardamon has to stay up late and then miss his work, because he's gonna start working more now, with the time getting better over here in the UK. Oh no. Well, I can see your comment now, Ada K. I don't know. I'm so sorry. I think Garden Bot the other day actually was mentioning that the comments were not posting. I'm so sorry, darling. I oh, actually, I did forget to do something for Toxic on stream, and I apologize. But I don't know. I think like people it's happening that oh, I know. Tech, believe me, I know. Tech, huh, okay? It's tech problems. Don't even get me started, because I've got them daily problems here. I think everywhere it is tech problems. But, um, oh, 1 second. Oh. Interesting. Sorry, one of my March was just sending me your conversations, and we only have the views that I saw. But try it again, maybe ADK, or trying to space out if you can't. Like sometimes you know how YouTube is weird with some words, so maybe just write it with like a lot of spaces in between. Try like that, because it might be one of those words that our lovely friend Whitey doesn't like. But there's a way of always get around it. So it's just sorry, thought we're still talking about time zone. um Sorry. Yeah, okay. Oh, is it? Oh, that's interesting. See, this is what I need you guys for, because I don't know how YouTube works or anything. Oh, a car wash. Hey, Paula, do you want to take my car and wash it too? Because my car needs washing. Actually, is one of the tasks that I have set for this week. Hopefully, the weather will be nice enough. That I need to wash my car and clean my car. It's not like dirty, but there's a lot of receipts of cheese twists and pastries in my car, and I need to clean that out. Because yeah, sometimes is and a lot of this bottles as well in the car, because apparently I have like a problem with them. I I think I have a problem. Oh, I know. I'm so sorry, Paula. Well, I hope I can keep you entertained at least. Because I can carry on talking for no ends, apparently. Um, it's actually a very good thing that I have. But if you guys give me a topic, I can always like have an opinion or something to say on it while I'm still searching and refreshing the court feeds for this. So actually, oh, you know what? I need to change as well. So my list for this week to accomplish of accomplishments in terms of not streaming, right? I know. Well, hopefully you have your headphones today, So you can listen to, well, me talking, apparently, because that's what I was gonna say. What I was gonna say, my list of accomplishments for this week, while I'm off from work, is I need to clean my car, clean the house, obviously, get done with the laundry that I need to get done, because that's gonna be a little bit lot at the moment. I need to finish the Lucy Let Be thing. I need to finish the other commitment that I have that I can't talk about it yet on it. And then we have to finish the spreadsheet and share the spreadsheet with you guys. Rest as well. It is on the list of the things to do, to rest. Cleaning is not fun. Absolutely not fun. I vamos. And good morning. Buenos dias, my friend. Definitely cleaning is not fun. But that's why this week I saw my new hours that I'm doing. I'm having an extra morning free so I can like help garden bot and around the house, because lately with working in the morning, streaming in the afternoon and everything, I haven't been able to help him as much. But now he's, like I said, he's gonna get busier with his work. I need to take the reins a little bit more again of the house, so I'm gonna be doing that the extra morning that I have. But I took advantage and I took another day off for tomorrow from work, just to rest, and as well because I had hours of holidays to take anyway. So I need to take them until the end of the month. So I was like, oh, okay, I'll take them tomorrow, and have kind of almost a week off and just relax and do things that I need to get done. Because otherwise I keep postponing and I keep like, oh, I'll do it tomorrow, and I never get done. Because also this weekend, me and Garden Pot are gonna be busy. We have a wedding on Saturday. So if we have a new trial, and hopefully they won't do on Saturdays, otherwise we're gonna have to catch up, because we have a wedding this Saturday. It's gonna be amazing. I cannot wait for it. I am so happy for our friends. They are getting married, so we're gonna be I'm gonna probably on the members video next week, or I'll try to post a picture on the YouTube of me and Gardenbot all dolled up for some reason on on YouTube, so you guys can see, and just for the reason why I don't know. But anyway, now that I said it, I'm gonna have to do it. So that's gonna be as well. Need to get prepared to that. I need to buy a present for our friends, so I need to get that done too. It is gonna be a week off, but it's gonna be having a lot to do. But I'm glad that I have the time and to relax as well. I want to take a day, hopefully, to do nothing as well. To play video games all day, to watch TV shows and lovely TV shows that normally I wouldn't. But as well, because it's all fun and games, but it's also oh, hang on, the courtroom that we are waiting. I think, yes, it is. It is here. But oh, hang on, I'll shut up. Oh, you guys are gonna love me because I'm gonna shut up. Hang on. Because I think I'm gonna shut up.
Does have significant family ties here in Greeley. He has brothers and sisters in the city that are happy and willing to let him stay with them. They've been a great support for him. Mr. Arevia had previously completed adult treatment court, and they had been there for him throughout that time and had been supporting him in the interim. This case arose out of a devastating incident in Mr. Aria's life where he lost his mother just at the end of 2024. Things have been going very well for him, but around that time he did fall back into some of the history of his substance abuse, as well as losing his job and his apartment. Those factors compounded, and they're probably the reason that we are here today. Mr. Arevia has indicated that if he was able to post a bond, get out of jail, he would make sure that he is following through on what he learned in adult treatment court, trying to make sure that he isn't abusing substances and is attending all of his court dates. He also indicated that he'd be perfectly fine with any substance abuse monitoring. He'd been doing that in the past, or an ankle monitor if the court deems that necessary. Mr. Arevia did inform me that he has almost no financial ability to post bond, we would just be asking the court to set personal cognizance bond or otherwise the lowest cash surety possible.
All right, thank you. Ms. Akers, anything else to bond?
People would essentially refer to the court. For the information for the court, Mr. Uribia finished was officially discharged from adult treatment court in November of 2024, and then we received these new charges in January of 25. So I would note just that the prior DUIs are from the 1990s. Has been in custody for some time. We really could just defer to the court. And if the court does grant a PR bond or modifies the bond, we would ask for substance abuse monitoring as a condition of that bond.
All right, thank you. Give me just a second here.
I apologize, Your Honor, I know you're reading. I think an original condition of bond was a TAD device or something equivalent. So that the people would be fine with the current conditions. But we defer to the court on any modification.
Okay, and I do see that is currently a condition of bond. All right, based on the information before the court and the history of the prior offenses, the court does find that bond generally is appropriate as set. I am going to modify it from a $7,500 surety bond to a $750 cash only bond with the same terms and conditions as previously ordered. Mr. Rush, how would you like to set this?
Thank you, Your Honor. We're just asking to set additional disposition.
All right, we'll set this for disposition. Ms. Akers, is this your case?
It is, Your Honor.
All right,
Your
what date
Honor?
do we have? I'm sorry, who's
Excuse me,
speaking?
Your Honor. This is Jeffrey Sanchez.
Mr. Sanchez, I'm not sure if you're on my docket right now, but I'm dealing with another case right now.
Oh, okay, I'll just wait. I'm sorry about that, sir.
All right, thank you, sir. What date do we have?
I'm sorry, Ms. Akers, this is your case? April 29th at 9:30.
April 29th at 9:30. Mr. Rush, does that work for you?
Yes, Your Honor. Thank you.
And Ms. Akers, April 29th at 9:30, does that work for the state?
Yes, Your Honor.
All right, then we'll continue this matter out for disposition to April 29th at 9:30. Mr. Arriva, sir, that will be your next court date, sir. Thank you.
Thank you, Your Honor.
The court will call 25 CR 115, People of the State of Colorado versus Candace Miller. Ms. Miller appears today with counsel Mr. Rush, and Ms. Akers appears today for the state. Ms. Akers, is there any VRA record the state needs to make today?
We are compliant for today's hearing. Sometimes the victim appears. I just asked the court if she would inquire as to if the victim is present on WebEx.
All right, thank you. Do we have any victims or victims representatives present or on the line on Candace Miller's case? All right, the court does not hear a response. Give me just a second here. Ms. Miller, I have received paperwork indicating that we have an agreement to resolve your case today. Ma'am, I just have some questions for you just to make sure that you understand that that's what we're doing today.
Okay,
To begin, ma'am, are you Candace Miller?
yes,
And how old are you, ma'am?
I'm 37,
And where were you born?
here in Greeley, Colorado.
And what is your level of education?
I graduated 5 colleges.
And ma'am, are you a veteran or active member of the U.S. military?
No, I am not.
Do you have any difficulty understanding the English language?
No,
Have you consumed any alcohol, drugs, or medication in the last 24 hours that would impair your ability to think clearly today?
no.
Have you ever been diagnosed with any mental health issues that would prevent you from understanding what we're doing here today?
I've been diagnosed with schizophrenia.
Okay. And ma'am, is your diagnosis such that you're having difficulty understanding what I'm talking about today, or
No,
do you feel comfortable that you've understood so far?
yeah,
All right. And Ms. Miller, if there's anything that I talk about today that you are confused about, will you please just stop me and let me know, and I'll try and explain it a different way?
yeah,
All right. Thank you, ma'am. And ma'am, have you had enough time to consider this agreement?
yes, I have, Your Honor.
Have you had enough time to consider the legal rights that you would be giving up by accepting this agreement today?
Yes, I have, Your Honor.
Do you understand, ma'am, that you don't have to plead guilty in this case today if you don't want to? You could enter pleas of not guilty, and we would set the matter for a jury trial. And if we proceeded to that jury trial, it would be the district attorney's burden to prove you guilty beyond a reasonable doubt. Do you understand that, ma'am?
Yes, I do, Your Honor.
And do you understand that you would give up that right to a jury trial by accepting this agreement today?
Yes, I do, Your Honor.
Is anybody forcing you to accept this agreement today against your own free will?
No, Your Honor.
Ms. Miller, the agreement in this case appears to be as follows. You would plead guilty to count 2, assault in the 3rd degree as a class 1 misdemeanor, count 4, duty upon striking an unattended vehicle, a class 2 traffic infraction, and count 6, unauthorized use of a motor vehicle, a class 1 misdemeanor. The remaining counts would be dismissed. As to count 2, the parties stipulate you would receive an 18-month period of supervised probation. As to count 4, the parties stipulate you would receive a 52 straight jail sentence with any credit for time served that you may have awarded against that sentence. And as to count 6, you would also be sentenced to an 18-month period of supervised probation. Those probationary sentences would be concurrent with each other. Conditions of your probation would include completion of a mental health evaluation and compliance with any recommended treatment, that you complete a substance use evaluation and comply with any recommended treatment, that you be monitored for sobriety. Additionally, you are stipulating to a factual basis and proximate cause for the purposes of restitution as to all charged, pled, and/or dismissed counts. There's an agreement between the parties that the state has exercised due diligence in attempting to identify a restitution figure, but have been unable to do so. So there's an agreement that they may reserve their right to seek restitution at a later date. Ms. Miller, is that your understanding of this agreement?
Yes, Your Honor.
Do you have any questions about that for me?
No, Your Honor.
And have you reviewed this agreement with your attorney?
Yes, I have, Your Honor.
Has your attorney answered all of your questions?
Yes, he has.
Are you satisfied with the work that Mr. Rush has done for you on this case?
Yes, I am.
Mr. Rush, did you review the plea agreement with Ms. Miller?
I did, Your Honor.
And did you review with Ms. Miller the elements and possible penalties of what she's pleading guilty to today?
Yes, I did.
Do you believe she understands her rights in this matter?
I do.
And Ms. Miller, do you agree with your attorney's answers to those questions?
Yes.
And do you have any final questions for me before we go forward?
The only question I have is that I have an appointment with the,
I can bring that up.
okay.
Ms. Miller's just concerned. She has an appointment for back surgery, so she was hoping for a little extra time to report to probation.
Okay. Ms. Miller, once we get to sentencing, we'll kind of talk about what your situation is and talk about what makes most sense for you.
Okay.
Okay. Do you have any other questions, Ms. Miller?
No, that's it.
Then, Ms. Miller, as to count 2, assault in the 3rd degree, a class 1 misdemeanor, count 4, a duty upon striking an unattended vehicle, a class 2 traffic infraction, and count 6, unauthorized use of a motor vehicle, a class 1 misdemeanor. How do you plead to those charges, ma'am? Guilty or not guilty?
Guilty.
And I'm sorry, ma'am, I couldn't hear you.
Guilty.
And are you pleading guilty to those charges today of your own free will?
Yes.
And Mr. Rush, as to a factual basis?
Waive, Your Honor.
All right, thank you. Ms. Miller, I do find that your pleas of guilty have been knowingly, intelligently, and voluntarily given, and that they are not the result of any undue influence or coercion on the part of anyone. That a factual basis for your pleas has been waived by counsel. So I will accept your pleas of guilty and enter judgment and conviction at this time. Ms. Akers, anything as to sentencing?
Your Honor, we'd ask for standard terms and conditions of probation, in addition to a mental health evaluation, a substance evaluation, and substance abuse monitoring as conditions of probation. And nothing further.
All right, thank you. Mr. Rush, anything as to sentencing?
Thank you, Your Honor. We do believe that agreement is appropriate. We'd ask the court to follow that. We'd only ask that the court waive all non-mandatory fines, fees, and costs for Ms. Miller, as she is currently indigent. And as she noted, she is currently using a walker, and she is scheduled for a back surgery. She was preparing for that prior to her incarceration. So we would just ask for a little leeway for the purposes of her reporting to probation.
And when is her surgery scheduled?
This Thursday, you said?
Yeah.
Thursday.
Thursday, okay. All right. And Ms. Miller, is there anything that you want to tell me before I impose sentence in this case?
No, that's all.
Okay. All right. Ms. Miller, I do find this agreement appropriate. I am going to follow the recommendations of the parties. As to counts 2 and count 6, I am going to sentence you to 18 months of supervised probation. Specific conditions of your probation will be that you complete a mental health evaluation and comply with any recommended treatment, that you be monitored for sobriety, that you not possess or consume any alcohol or controlled substances without a valid prescription or a valid medical marijuana card, and that you complete a substance use evaluation and comply with any recommended treatment. It will additionally be a condition of your probation that you pay restitution in an amount to be determined in the future. I am going to give the state 45 days to file notice of that amount, and if one is filed, I will give your attorney 14 days to object. Counts 2 and count 6 will run concurrently with each other. As to count 4, I am going to sentence you to 52 days in the Weld County Jail. Mr. Rush, I presume she has 52 days credit?
Yes, Your Honor.
All right. I do find that you have 52 days credit for time served against that sentence. So that sentence has been completed. Given that you are currently in custody, I do find that you are currently indigent and lack the current financial ability to pay some of these fees. So I'm going to waive any probation supervision fees, cost of care fees, public defender fees, and any other waivable costs and fees associated with your case. There will still be some mandatory fees that you will be liable for, as well as restitution if that's ordered in the future, and payment of those fees will be a condition of your sentence. Ms. Miller, as far as you're aware, do you have any other cases besides this one?
No, that's the only case I have, Your Honor.
Okay, so Ms. Miller, you should be released from custody on this case today. What I'm going to have you do, Ms. Miller, I'm going to have you contact probation tomorrow. I'm okay if that's a phone call, and just let them know about your surgery. They may need you to get some medical information for you, and then I'm sure they'll be able to set you up an appointment after you are recovered from your surgery to sign your terms and conditions of probation. So just give them a call tomorrow once you're out, and they'll be able to give you some instructions in the future.
Okay.
All right. Ms. Miller, I do want to wish you good luck. I'm really glad to see that you're getting out of custody today. I hope that probation goes well for you, and hopefully your surgery goes well as well. So good luck to you, man.
Thank you.
All right. Thank you, man.
Thank you, Your Honor.
All right. Do we have Jermaine Jackson on the line from the Department of Youth Services?
Yeah.
All right. Thank you. The court will call 24 CR 1421, People of the State of Colorado versus Jermaine Jackson. Mr. Jackson appears today with counsel Mr. Hopkins, and Ms. Akers appears today for the state. Ms. Akers, is there any VRA record the state needs to make today?
We are compliant for today's.
All right. Thank you. Mr. Hopkins, how would you like to proceed?
Your Honor, Ms. Akers took the time to meet with me in person for a pretty extended period of time. We reached an agreement just yesterday. It involves a probation sentence with some special agreements and conditions. We still need to get the paperwork ready. I guess I would defer to Ms. Akers how much time she needs for that. And then one caveat, Jermaine, Mr. Jackson has been appearing virtually, as is obvious. We need to consider whether the court's requiring him to appear in person and the time for a writ and things of that nature. If the court is allowing virtual and Ms. Akers is okay with that, it can happen sooner than later, I suppose, depending on the court schedule. Last caveat, I am unavailable for a 3-week period starting on March 24 through April 11 due to a trial.
And Mr. Hopkins, remind me, Mr. Jackson's at Lookout Mountain. Am I remembering correctly?
Yeah.
That is correct, Your Honor.
Okay, all right. I'm fine with a virtual appearance for the purposes of the plea, given his situation at Lookout Mountain. Ms. Akers, how much time do you think the parties will need to finalize the paperwork? I can try and bring you back maybe on Friday. Do we have time on Friday? Let me see what.
Judge, I think just realistically with trying to cover Ms. Goodman's docket, my docket,
Okay.
everything, I think Friday might be pushing it. I don't
Sure.
want to, Mr. Jackson's serving a sentence, so it's not getting out once we
Okay.
enter this agreement. I'm not trying to delay it any longer.
No,
but
that's fair. Let's see where we can set this. And Ms. Akers, is this your case? Okay.
We can do April 1st and 9th.
So Mr. Hopkins is out. And I'm sorry, Mr. Hopkins, you said from March 24th to when are you at?
Through April 11, sorry.
April 11th.
Sorry. So we're looking at April 29th at 9:30.
April 29th at 9:30. Mr. Hopkins, does that work for you?
And I'm sorry, I am also gone then out of the state due to a medical procedure.
Sure.
April May 1st.
May 1st at what time? May 1st at 9 a.m. Mr. Hopkins, can you do that?
And I am sorry, I'm causing so much trouble. I am gone the 28th through the 5th of May.
Okay. Can you look for a date after the 5th?
Do May 13th at 8.
I have May 13th at 8:30. Mr. Hopkins, does that work?
That's fine, Your Honor. For me, I know the court's busy. There's no way we can get this in those 2 weeks, those 2 remaining weeks in April before I leave.
That sounds like we're in trial, unfortunately, so I'm not sure we'll be able to do that.
Can I get the date and time one more time?
I'm sorry, May 13th at 8:30.
Thank you.
And Ms. Akers, May 13th at 8:30, does that work for the state? All right, then we'll continue this matter over to May 13th at 8:30. Mr. Jackson, sir, that will be your next court date, sir.
Okay, thank you. I appreciate it.
All right, thank you, sir.
Thank you. Have a nice day.
Thank you, Your Honor.
And they're waiting for us to call on Ms. Rodriguez? They can bring her up whenever. Yeah, just have her come up. I thought they were bringing them all up at the same time. All right, the court will call 24 CR 692 and 25 CR 175, People of the State of Colorado versus Stephen Gomez-Burseno. Is Mr. Gomez-Burseno present? All right, thank you. Mr. Gomez-Burseno appears today with counsel Mr. Rush. Ms. Akers appears for the state. Ms. Akers, is there any VRA record the state needs to make today?
Remember, we are compliant for today's hearing.
All right, thank you. Mr. Rush, how would you like to proceed?
Thank you, Your Honor. The 24 CR case, we'll just ask to set all the case for arraignment.
All right, thank you. We'll set both cases over for arraignment. Ms. Akers, is this your case?
Ms. Goodman. Now they're mine.
Okay, all right. We set this out for arraignment. You said, haven't you? It's hard.
You can do June 10th at 9:30.
June 10th at 9:30. Mr. Rush, does that work for you?
Absolutely, Your Honor. And if there's no agreement reached at that time, could Mr. Gomez-Burseno appear virtually?
I'm fine with the virtual appearance. And Ms. Akers, June 10th at 9:30, does that work for the state?
Yes, thank you.
All right, then Mr. Gomez-Burseno, I'm going to set this matter out for arraignment to June 10th at 9:30. Just make sure you stay in contact with your attorney so you know what you want to do when we come back. All right, thank you, sir.
Thank you, Your Honor.
Both cases. All right, the court will call 24 CR 131, People of the State of Colorado versus Carlito Sanchez. Is Carlito Sanchez present?
Yes, Your Honor.
All right, thank you. Mr. Sanchez appears today with counsel Ms. Thomas, and Ms. Akers appears today for the state. Give me just a moment. Ms. Akers, any VRA record the state needs to make today?
Compliant for purposes of today.
All right, thank you. Ms. Thomas, how would you like to proceed?
Thank you, Your Honor. It's my understanding the district attorney is working on getting a VRA offer for us. They're hoping to get that within the next few days, hopefully at the end of the week. And so our hope is to be able to set this sometime in April so we can work on some negotiations and hopefully come to a resolution soon.
All right, thank you. We'll set this matter out for disposition. Ms. Akers, is this your case?
Yes, sir.
All right. What date do we have? April 3rd at 10 a.m. Ms. Thomas, does that work for you?
If I could just double check.
Sure. And I can set that out farther if you need more time than that.
That does work, Your Honor. Thank you.
And Ms. Akers, April 3rd at 10 a.m., does that work for the state?
Yes, Your Honor.
All right, then, Mr. Sanchez, I'm going to continue this matter out to April 3rd at 10 a.m. That'll be your next court date, sir.
All right, thank you, Your
All
Honor.
right, thank you, sir. Are they bringing up Ms. Rodriguez? Is she downstairs?
That's your next court date, okay? April 3rd at 10 a.m. Call me if you need anything, okay? Okay, thank you so much.
Mr. McCormick,
Yes?
I know you're crazy busy. When you get a moment, can you send me, if you could just email me your exhibit list, even the original one, that's fine. Mine is just really messy and I want a clean copy for the file.
See what I can do.
Thank you.
All right, the court will call, I'm sorry, just a second here. Court will call 21 CR 2296, People of the State of Colorado versus Stacy Rodriguez. Ms. Rodriguez appears today with counsels Ms. Devereaux and Ms. Trujillo. Mr. McCormick appears today for the state. We come on for day 12 of jury trial. Yesterday, we conducted a jury instruction conference. After 5 yesterday, I received an additional email from the defense requesting additional jury instructions. Ms. Trujillo, any record that you want to make, go ahead.
Do you want to make the record?
Or Ms. Devereaux.
It's fine. Judge, I apologize. When Mr. Hio was doing jury instructions yesterday, to be frank, I was working on other things. I didn't catch it until afterwards, so I apologize. But we did endorse both different subsections of use of deadly force. And so I do believe it's appropriate for the jury to have the jury instructions that we submitted. And I also included the second-degree assaults that would be applicable in this situation. I did not include every single second-degree assault because that would make sense. But I think there's sufficient facts here that a jury could believe that Ms. Rodriguez was using self-defense, deadly physical force, to defend herself from what she reasonably perceived to be second-degree assaults, and the ones specifically including the one where it's recklessly causing SBI with a deadly weapon. I pulled those from Colgi. They shouldn't be anything super surprising. We've endorsed it. It was just a mistake in terms of on our part that we didn't recognize it wasn't included.
All right, and Mr. McCormick, any record, go ahead.
Judge, thank you. I would object to these additional instructions twofold. Number one, I think in order to be consistent with the ones that the court's already incorporated, and for the record, I believe that this information is incorporated in the instructions the court already has prepared. I would also, if the court is inclined to do that, I would ask that the reasonable person standard be placed in that instruction, but I believe it's H12 from Colgi. I didn't number the court's instructions, but it's kind of the second evidence presented in this case has raised the affirmative defense of deadly physical force and defensive person, et cetera. And then the 5 paragraphs, I'd note that I think paragraph 3 covers the information that they have in there. I think the concern too is that we're getting into a position here where we're going to cause confusion to the jury with all the additional instructions. So at this point, I would object, but if the court does grant it, I do have some additional comments that I'd like to make.
All right, why don't you just give the additional comments so I can.
Sure. I think it has to incorporate the reasonable person standard to be consistent with the other instructions that the court is intending on offering. As far as the definitional on each of the bottom of the proposed charges, I think the court can reincorporate that into the definitional instruction. And then lastly, the last page, the reasonableness encompasses a range of beliefs and conduct. I would object to that. I think their reasonableness is already defined within the context of the body of the jury instructions, and I don't believe that there's any Colgi instruction that this is taken from. I believe this is taken from case law. And again, I think it's covered in the rest of the instructions, so we would object.
All right, so given that we had a jury instruction conference yesterday, with respect to the last instruction of the defense proposed packet, the reasonableness instruction, I am going to deny that request, given that it wasn't made when we had our jury instruction conference. I am going to include the self-defense regarding the first degree and second degree assault, because I believe it would be error for this court not to do so. Ms. Devereaux, however, I am going to order that if you want that you are going to need to provide me a copy that is consistent with the other self-defense instructions. I note that you left out the initial aggressor language and the provocation language from that instruction. Additionally, I am going to have the defense provide me a new definitional instruction with the definition of deadly weapon contained in it, as opposed to putting that in that instruction. I'm also going to have the defense add the same sentence that we've added in the other
Sorry,
self-defense
Judge,
instruction.
I'm sorry, can I just go back? I'm just gonna write this all down.
Sure.
Okay, so
So basically what I am saying is that this self-defense instruction needs to be consistent with the other self-defense instructions. So you've not included the initial aggressor or the provocation paragraphs. I'm going to have you include those same paragraphs. In one of the instructions, you include the definition of deadly weapon. I think it's more appropriate to include that with the other definitions, as well as the bodily injury definition. So I'm going to add that you resubmit that definitional instruction, the same copy that I emailed you guys last night, but with those two definitions attached. If there's any other definitions that aren't previously included in the instructions, I'm going to ask that you add those in as well. And I'm also going to ask that you add in the line, the reasonable sober person sentence that's also included in the other self-defense instructions, and submit that to the court as soon as possible. I would make that change myself, but I simply don't have time to do so this morning, given that was the point of having the jury instruction conference. So if you want to have that included, you're going to have to make those changes and submit those to the court.
I will do, Your Honor. And the other, I was looking back at the instructions that the court sent us last night. I did find some errors, and I just wanted to notify the court and the parties.
Sure.
To start with, on the first degree murder elemental jury instruction.
The second two.
Should be on page 17. That's helpful.
All right, go ahead.
On line number 5, it reads to cause the death of a person other than himself. It should be herself.
Okay.
Is the court okay if I just change that? And I'm assuming Mr.
No,
McCormick.
I have that up. I'll change it right
Okay.
now. Any other typos that you saw?
Yes, Your Honor. I also saw that there is the same instruction twice for the evidence presented in this case will raise the question of self-defense with respect to manslaughter.
Give me just a second there. Do you know the page numbers?
Pages 21 and 22. I'm sorry, 22 and 23.
So I don't think those are the same. There's one for non-deadly physical force, and then there's one for deadly physical force. So
okay.
The first instruction reads a person is justified in using physical force, and then the other one reads a person is justified in using deadly physical force. And they're very similar, but there's some change in language there regarding the lesser degree of force.
I see that now. And then I think that was all I saw.
Okay. And Mr. McCormick, any typos that you saw?
I didn't see any yet, Judge. I'm still reviewing, but I haven't seen any yet.
Okay. I'll need you to send over, Ms. Devereaux, those instructions by 10 so my staff can start printing those and getting copies together.
Okay, thank you.
All right. We'll be in recess in this matter until until noon.
Thank you.
All right.
Your
Mr.
Honor?
Duran, are you ready on Mr. Rosales' case?
Okay.
Okay. All right. The court will call 21 CR 1320 and 23 CR 1381. People of the state of Colorado versus Joshua Rosales. Mr. Rosales appears today with counsel Mr. Duran, and Ms. Akers appears today for the state. Ms. Akers, is there any VRA record the state needs to make today?
Your Honor, we are compliant for today's hearing.
All right. Thank you. Mr. Duran, how would you like to proceed?
Judge, I'm just asking for an additional disposition in this date, or in this case, and for Mr. Rosales to be able to appear virtually. We just need to continue going over his case since it was transferred to me from Ms. Sidley Mckee.
Okay. Ms. Akers, the 23 CR case was set for arraignment. Do you have any objection to an additional arraignment?
I do not, Your Honor. I know Ms. Sidley Mckee and I have been engaged in some extensive negotiations, so I know there might be a lot for Mr. Duran to kind of get up to speed on with all of our back and forth. So based on that, I have no objection to a continued arraignment.
All right. We'll set this matter out for another arraignment, and then the 21 CR case will continue to trail. What date do we have? May 1st at 8:30. Mr. Duran, does that work for you?
Yes, and the court's okay with a virtual appearance for that?
Yes, I'm fine. And Ms. Akers, May 1st at 8:30, does that work for the state?
It does, Your Honor. Thank you.
All right. Then, Mr. Rosales, I'm going to continue this matter over to May 1st at 8:30. Make sure you stay in contact with your attorney so you know what you want to do when you come back.
All right, thank you.
Thank you, sir.
Thank you.
All right. The court will call 17 CR 921, People of the State of Colorado versus Ronald Wirch. Is Mr. Wirch present? Do we have Ronald Wirch present or on the line? Mr. Duran, I'm sorry, Mr. Rush, I don't hear a response. Do you want a moment to reach out to Mr. Wirch?
Yes, thank you, Your Honor.
Okay, we'll pass that for a moment. The court will call 24 CR 123, People of the State of Colorado versus Ann Vick. Is Ann Vick present? All right, thank you. Ms. Vick appears today with counsel Ms. Morris, and Mr. Wasserman, I believe, appears for the state. Mr. Wasserman, are you on the line, sir?
Yes, I am, Judge. I'm appearing via WebEx. Good morning, Judge.
All right, good morning. Give me just a second here. All right, thank you. We're set today for a status conference after this matter was transferred to this division from Division 15. I've received a sworn financial application for the Public Defender's Office. I've reviewed that application. Ms. Morris, I am going to go ahead and approve that application. I assume the Public Defender's Office has done what they needed to do to confirm Ms. Vick's financial situation. I'm also generally aware of Ms. Vick's business ventures and Mr. Wasserman. I assume that you have more information about this situation than I do. So if either party needs us to address that financial application at some point in the future, I just ask that the motion be filed and we'll address that if that becomes necessary. Other than that, Ms. Morris, how would you like to set this?
Yes, Your Honor, this was just open to me yesterday afternoon, so I would just need an opportunity to get caught up and speak with Ms. Vick if we could just set this case over.
Okay. So what I'm going to do, Ms. Morris, I am going to set this matter over. However, just reviewing the history of the case, it looks like you're the third attorney on this case. This case is over a year old, and I have a little bit of concerns that it doesn't appear anything substantial has happened in that year. So I'm going to give you some time, but it might not be as much time as I might usually give in different circumstances. Some of that delay, unfortunately, is going to have to be borne by Ms. Vick. What I'm intending on doing is setting this out for arraignment, but I'm going to set it out about 90 to 120 days so that you can have ample time to review discovery, speak with Ms. Vick before we get this case set, if that's what we're doing when we come back. So what date do we have in approximately that time frame, please? That's fine. At what time?
27th at 8:30.
June 27th at 8:30 for arraignment. Ms. Morris, does that work for you and Ms. Vick?
That works for us, Your Honor.
And Mr. Wasserman, June 27th at 8:30, does that work for you, sir?
Unfortunately, Judge, I'm on a holiday break over the July 4th. I think it starts that day. If we can do a little bit earlier or post July 4th weekend, I would do either kind of within that 90 day window or so that the court signaled.
Can you give me the beginning and end dates of the period that you're going to be at?
Yes, Judge. It will be, that June 27th date through the week of July 4th.
July 4th. Okay. So can you give me something before or after? Either one's okay.
I'm sorry?
Either before or after is fine.
Okay, we can do June 12th at 8:30.
June 12th at 8:30. I'm sorry, Ms. Morris, does that work for you and Ms. Vick?
Yeah. That works, Your Honor.
And Mr. Wasserman, June 12th at 8:30, does that work for the state?
That works as well, Judge. And one thing I appreciate the court's just perspective as it relates to the posture of this case right now. I would note, Your Honor, at the last court date, Ms. Vick indicated that she was looking to hire private counsel. And I had asked the court if in case she's unable to hire private counsel, at the very least, we could get the ball rolling with her applying for the public defender's office. She, of course, abided by the court's minute orders and applied for the public defender's office. I'm just making a record right now because I understand there was a conflict with the previous judge, and now Your Honor is presiding over the case. Is that the court was correct that this is now the third attorney on record, and I'm just flagging if an issue does become potentially ripe later on, where we're 90 days into the representation by the public defender's office, and now we have essentially a new attorney, and this whole time is basically her just getting more time to get a private attorney. So if that's the intention, I just would like some transparency so we know, okay, she intends to get a private attorney or she continues to want to be represented by the public defender's office. So we may particularly have an earlier setting than, 3 to 4 months out, only to be back at square one. If there's an earlier date, okay, I plan to get a private attorney, let's set a date in 45 days. Because I just don't want to waste more and more time. We're back in 3 months, and then now we're at a private attorney.
No, I completely understand your concerns, Mr. Wasserman. So I tell you right now, Ms. Vick is represented by Ms. Morris. I know Ms. Morris to be a competent attorney. I have no doubt that she will do a good job by Ms. Vick. Ms. Vick, I want to let you know, I'm not really have a lot of patience for people using changes of attorneys for purposes of delay. I could tell you when we come back, the parties should be prepared to go ahead and set trial on this. If you have a new attorney, whether that's his first day when we come back at June, you should probably let that new attorney know that we're going to set trial. So he or she may have a shorter period of time to get up to speed. But when we come back in June, we're going to get this matter set for trial. Mr. Wasserman, does that resolve your concerns?
It does, Judge. Thank you.
Okay, all right. And Mr. Wasserman, you may continue to appear remotely for any non-motion hearing type of settings. And Ms. Vick, if you want to appear remotely for any non-motions hearing type of sentencing, you're certainly welcome to appear virtually if you want to. Just make sure you talk to your attorney about that, so she may have different advice for you. All right, then we'll continue this matter out for arraignment to June 12th at 8:30.
Thank you.
All right.
Thank you, Judge.
Thank you. Ms. Morris, are you ready on Ms. Avalos' case?
Yes, we are.
Okay. The court will call 23 CR 1585, People of the State of Colorado versus Margie Avalos. Ms. Avalos appears today with counsel, Ms. Morris, and Ms. Akers appears today for the state. Ms. Akers, any VRA record?
Your Honor, we are compliant for purposes of today.
All right, thank you. Ms. Morris, how would you like to proceed?
Yes, Your Honor. We would reserve the right to a preliminary hearing now that Ms. Avalos is back in custody. But I did reach out to the DA. We're hoping to receive an offer. So right now, we just asked to set for a disposition and bond reduction hearing.
All right, we'll set this matter out for disposition in hearing on bond. Ms. Akers, is this your case?
It is.
All right, what date do we have? April 29th at 10 a.m. Ms. Morris, does that work for you?
Yes.
And Ms. Akers, April 29th at 10 a.m., does that work for the state?
It does, Your Honor. Thank you.
All right, then we'll continue this matter out for disposition to April 29th at 10 a.m. Ms. Avalos, ma'am, that will be your next court date, ma'am. Thank you.
Thank you.
All right. And deputies, do you have Mr. Casas is here. Thank you. The court will call 25 CR 193, People of the State of Colorado versus Jorge Casas. Mr. Casas appears today with counsel Ms. Morris, and Ms. Akers appears today for the state. Ms. Akers, any VRA record?
We are compliant for today, Your Honor.
All right, thank you. Mr. Casas, I just wanted to address you real briefly. I received a couple of the motions that you filed. So long as you're represented by an attorney, I'm only going to consider motions filed by your attorney of record. So if there's something that you want to bring up to the court, you'll need to go through your attorney to do that. Ms. Morris, how would you like to proceed?
Yes, Your Honor. We would be asking to address bond today. I believe we were set for a bond reduction hearing, and then we're waiting to see if we'll receive an offer on this case. So after that, we would just ask to set for a disposition.
All right, thank you. Ms. Morris, anything else to bond? Go ahead.
Yes, Your Honor. Right now, Mr. Casas is unable to post the current bond, but he does have his entire family here in the northern Colorado area in Lock Buoy. He was currently looking for work before he was brought into custody and is hoping to continue his job search. He was living with his mother. His mother does have early onset Alzheimer's, and she does need someone to stay with her. And he was acting as her caretaker for both her health and for the household. So he's hopeful that he can go back to doing that. Additionally, he is very eager to get into either a rehab facility or a mental health treatment facility. He's been looking into programs in Boulder, as well as in South Denver at Border Adventist. And that is his main concern right now, is that he wants to get into treatment as soon as possible and get back to his family. He recently became a trustee, so he's doing very well in custody. And we would just ask if the court is willing to modify to a PR bond, potentially with other non-monetary conditions, or lower his bond to $200 or $300 cash only.
All right. And Ms. Morris, do you know the Boulder case, is that still going on, or is that resolved?
He did just resolve that with a probationary sentence where he'll be doing mental health treatment and substance abuse treatment. So that's something else he's eager to get started on.
Okay. Ms. Akers, anything else to bond?
Your Honor, the people would object to a PR bond, just noting the Boulder case. Apparently he's resolved that, but he also has still pending a harassment case here in Weld County, 24M964. We'd also note that the pretrial services report had he was in a category 4 with a total score of 16. So there is some concerns for his ability to remain law abiding, and so we would object to a PR bond, and we defer to any modifications of bond to the court.
All right. What I'm going to do, I don't find a PR bond appropriate, but I do find that some modification is appropriate. Bond right now is currently set at a $5,000 surety bond. What I'm going to do, Mr. Casas, I'm going to reset that at a $250 cash only bond with the same terms and conditions as previously ordered. And Ms. Morris, do you know right now, does Mr. Casas believe he'll post that bond?
Probably not, Your Honor, so we could set for in custody.
All right. And do you want to set for a disposition?
Yes, Your Honor, I did reach out about an offer. I just have not heard back yet. I know Mr. McCormick has been in and out of trial. I believe it's Ms. Goodman's case.
Okay. All right. We'll set this matter out for disposition. What date do we have?
For now, it's technically Ms. Goodman's, but if it has her name, it's basically mine.
Okay. Could do April 29th at.
April 29th at 10 a.m. Ms. Morris, does that work for you?
Yes.
And Ms. Akers, April 29th at 10 a.m., does that work for the state?
Yes, sir, it does.
All right, then, Mr. Casas, I'm going to continue this matter out for disposition to April 29th at 10 a.m. That'll be your next court date, sir. Thank you.
Thank you.
Deputies, do you have Titus Reeves downstairs? Is he in custody or is he at Platt? Do we know? Oh, he's at Platt, okay. Do we have Titus Reeves on the line from Platt? I think you're probably going to have to call them. Yeah, we can call them and get them on. All right, Mr. Rush, are you ready on Mr. Wirch's case? Yes. Okay, the court will call 17 CR 921, People of the State of Colorado versus Ronald Wirch. Is Mr. Wirch present or on the line?
I believe he is the number ending in 15.
15. Mr. Wirch, are you there, sir?
Yes, I'm here, Your Honor.
All right, thank you, sir. Mr. Wirch appears today with counsel. Mr. Rush, Ms. Akers appears today for the state. Mr. Rush, how would you like to proceed?
Thank you, Your Honor. I do believe we have an agreement reached if we could get one final disposition on this matter.
Sure. We'll go ahead and set this matter out for disposition. Ms. Akers, is this your case?
For intensive purposes now, yes.
Okay. All right. What date do we have? April 29th at what time? April 29th at 10 a.m. Mr. Rush, does that work for you?
Absolutely.
And Ms. Akers, April 29th at 10, does that work for the state?
It does, Your Honor, thank you.
All right, then we'll continue this matter out for disposition to April 29th at 10 a.m. Mr. Wirch, sir, that will be your next court date, sir. Thank you.
Thank
All right, thank you, Your Honor.
All right, we'll be in a brief recess till we get Mr. Reeves on.
Your Honor.
Yes, sir.
Excuse me, Judge Villa. This is Jeff Sanchez again. I don't mean to bother you, but is there any way that I could speak with Kyle Rush before I go to court?
So, Mr. Rush or Mr. Sanchez, you certainly can. I don't actually see you on the docket today, so I'm not sure if your case got moved. Give me just a second. Do you know, Mr. Rush?
I don't believe it did. We were scheduled for the beginning of April. So
I don't recall his name being on the docket.
but I'd be happy to give you a call after court, Mr. Sanchez.
Oh, I'm sorry. I was under the impression it was today on the 11th.
Let me check for you, Mr. Sanchez.
Okay, thank you, Judge.
So, Mr. Rush, I think I have this set for arraignment on April 1st at 10:30. Is that what you have?
Yes, Your Honor.
Okay. So, Mr. Sanchez, I show your next court date on April 1st at 10:30. So you don't have court today, and it sounds like Mr. Rush, you can reach out to him when you have a second.
Absolutely. Mr. Sanchez, do you have a different number now? I'm seeing a different last digits there than I had previously.
I do not have a phone at the moment, sir. I'm actually calling from a motel room, so.
How would you like me to get in touch with you?
I've been leaving you some messages. I guess I can call you sometime today if you'll just tell me what time.
Yeah, if you could give me a call around noon.
Okay, thank you very much, sir. And thank you very much, Your Honor. I appreciate it.
Thank you, Mr. Sanchez.
Thank you, the court.
You said 2:50.
I keep wanting to talk because the judge said that they are gonna go on break, but he hasn't said anything, so I don't know what to do. So probably I'm not gonna mute the stream, but I'm gonna mute for use, and then if anything comes up, we'll do that, and then hopefully I won't be too confused. 1 second. Well, right.
Yeah.
Because I think the judge may have forgot to the camera on or the mic on. I don't know. Because they carry on talking, but well, they're not say anything court cases. So hang on 1 second. Sorry, it's just a friend asking for what time the court is gonna be on, and if Stacy is finished. Sorry. There you go. So I was just like I think the court is on a break at the moment, but it was interesting I was glad that we actually kind of are watching this feed, because we had something spicy-ish happening today in court in the baby Huey case. Yes, it's in the Stacey Rodriguez case, which that we probably would not have heard or seen otherwise if we were not doing. Oh, hang on.
Reeves on the line from Platt.
Yes, sir.
He's calling
All
me
right,
in another
thank
case.
you. The court will call 24 CR 2027, People of the State of Colorado versus Titus Reeves. Mr. Reeves appears today with counsel, Mr. Rush, and Ms. Akers appears today for the state. Ms. Akers, is there any VRA record the state needs to make today?
Your Honor, we are VRA compliant for today.
All right, thank you. Mr. Rush, how would you like to proceed?
Thank you, Your Honor. They called in. I wouldn't be able to have a
Yes,
breakout.
they're called in.
Okay, so I wouldn't have a chance to have a breakout room with them. Don't think that's.
I think you, at Platt, is there a phone number that Mr. Reeves' attorney can call him at over there before we get started? Or Mr. Reeves, are you there by yourself?
I'm here by myself right now, sir.
Okay.
I'm letting him know I have this court running over, so he's probably going to be a little late.
I don't believe this is the utmost necessity, Your Honor. I could just request an additional disposition.
Okay, okay, all right, that sounds good. And Ms. Akers, is this your case?
Yeah.
Okay. We'll set this out for disposition. What date do we have? April 29th at 10:30. Mr. Rush, does that work for you?
Absolutely, Your Honor.
And Ms. Akers, does that work for the state?
It does, Your Honor. I would like to bring something to the court's attention.
Sure.
So Mr. Reeves is currently basically he's serving the remainder of a parole sentence at Platte Valley. I've spoken with the case manager there. The parole holder is finished, or they lose jurisdiction on March 26th of this year. He's currently on a PR bond and on this matter, the 24 CR 2027 case. Based on my notes, I believe that's largely because of his sentence at Platte. So I didn't file notice of this. I'm not trying to argue for extra bond conditions. I'm just trying to put this on the court's radar that he'll be released from Platte prior to our next court date. There's no requirement for pretrial services or anything like that in the current 24 CR case, just based upon, I think, just the status of when he was given that bond.
Okay. All right. I appreciate that you bringing that to my attention. I haven't reviewed the record, but the reasons that you're telling me that Magistrate Armstrong likely gave a PR bond makes sense to me. I'll address that if you believe I need to address that, Ms. Akers. You can go ahead and file something, and I'll consider anything that you have filed. Mr. Rush, I'm not sure when you are speaking to Mr. Reeves, but when you do speak to Mr. Reeves, if it looks like his release is imminent, if you'll please just go over the application process and so on and so forth, just so that he's aware of that.
Can do.
All right, then, Mr. Reeves, we'll see you back here on April 29th at 10:30, sir.
Yes, sir. Have a good day.
All right, thank you, sir. Thank you, sir. I appreciate that.
Thank you.
All right, court will be in a brief recess until 9:30.
Well, did he say 9:30? That's like 3 minutes. Huh? Is he gonna? I feel really bad for this judge. He's having like a 3 minute break. Well, considering knowing this court probably will be more than 3 minutes, but wow, this judge definitely has a lot of it on his plate. Considering like he's handling his docket before sentencing in half an hour, that's gonna take about 2 hours, he said. Then he has closings and deliberations
Oh, and
on
on
another trial.
that stuff I gave you, the copy.
That is just crazy how busy. Yeah, it's definitely no way it's gonna be in 3 minutes. Cause like, what is he gonna do in 3 minutes? Breathe. I feel bad for this judge. I mean, he maybe during the trial was the longest time that he had nothing to do, really. Um, but I feel bad actually for this judge. He has a lot of cases, and I think many judges all across the country feel the same. That they have a lot of cases and a lot of going on, and barely have time to breathe, and that's shouldn't be like that. They should be able to pay attention to the case and to the circumstance that is happening and everything. So it is not an easy job to be a judge. Sometimes I used to think this before I started streaming and watching court, that being a judge, you just sit there listening to lawyers argue and you don't do much. They do a lot of stuff. Never really thought about that, and sometimes I am a little bit too harsh on them, but it's all fun and games. But probably the most breaks this judge had was during the trial, and not well, not right now, because now is like back-to-back cases, having 3 minute breaks, and then having a sentencing in half an hour. Yeah, exactly. And this poor judges sometimes don't even have a 1 hour. It's just crazy. So oh, hats to them. Very well done. And this judge seems a very good judge, even though he's kind of new, because Denise did tell us yesterday that this judge has only been in the bench since 2019, so he's a baby judge. But he seems very articulate right now. Maybe he's not as practiced as on trials as he is on a court docket. Hey, Pickles, nice to see you. Good morning, friend. Nice for you to show up. No, I'm joking, to show up. I am so sorry. It's fine. Hey, welcome in, my friend. I hope you're okay. Happy Tuesday. We are watching just some court docket situations from the judge that we've been following. I found this WebEx thing, and we have already seen Baby Huey too. And the very awesome, lovely, annoying attorneys. But they've gone on, and now we're just watching this next half hour of docket, and then we have the sentencing in about half an hour that he mentioned yesterday. That's why we are hanging out with the judge so much, and then eventually we are gonna go to our court trial later on. But don't forget that in about an hour, less than an hour now, sadly, I'm gonna pop out. Garden bot will come in because I have my doctor's appointment, and I'll come back to redirect us to the new stream. But between 1 and 2 p.m. Eastern, we are going to take a break, a lunch break. Sorry, someone is whispering in my ear. In the court, they're still on break. So we're gonna take a break between 1 and 2 p.m. Eastern. We have a new stream already set up for the court case, for the trial we've been following. But then at the end of this one, I'll redirect everybody to the new one, to the new stream, just in case you get lost on your your way there. So I'll just redirect you all to there, because I actually learned how to do that the other day. I am so impressed with myself, and so we can start doing that between streams. And during that court break, during that during the deliberations of our trial, we're gonna be watching the Lori Vallow Daybell hearing, because it's not gonna be live stream, but it's gonna be posted as a video. But we're gonna watch that. No. We're not swapping right now. We are swapping in a few hours, in like an hour and a half from now. So let me see. At 1 p.m. Eastern, Pickles, we're gonna be changing streams, okay? But I will redirect you there. So, hang on. So, yeah.
All right, the court will call 25 CR 138, 24 CR 1624, and 22 CR 677. People of the state of Colorado versus Aaron Greiner. Ms. Greiner appears today with counsel Ms. Morris, and Ms. Akers appears for the state. Ms. Akers, is there any VRA record the state needs to make today?
Just 1 second, Your Honor.
Sure.
So we are half VRA compliant, and this was moved from a different time. We emailed we contacted in 25 CR 138 the deputy, and we attempted contact with the other victim, but we were not able to leave a voicemail or notify her. We made attempts. I know that this was set for a bond hearing today, so I will just note that for the court. In the 22 CR case, that's non-VRA, and in the 24 CR case, the victim has opted out of notifications, so.
Okay. All right, thank you. Ms. Morris, how would you like to proceed?
Yes, Your Honor. We are waiting to see if the district attorney is in a position to extend an offer on this case. I know we were set to address bond today. I don't know if the court is able to do that or not.
I believe we're able to do that. So why don't you go ahead? If there's any bond argument that you want to make, why don't you go ahead?
Ms. Greiner has been in Colorado on and off for the last 15 years. She does have 2 adult children here in Greeley and her mother's side of the family in Denver. Her main concern right now is that she was about to check into a rehab facility before she was brought into custody. She was accepted into the Serenity House, and they have a bed for her. She also received a grant that will cover her stay there as long as she reports sometime this month. So in the next couple of weeks, she's very, very eager. That is what she wants more than anything right now, is to get into treatment. Beyond that, she is having some health issues. She was having some kidney stones before being brought into custody, and had an appointment at UC Health to see a doctor about that. And unfortunately, she was unable to do that. She was living in Fort Collins before being brought into custody, so she is local to the area. She's open to any non-monetary conditions that the court thinks might be appropriate, but right now she doesn't have any financial ability to post any sort of monetary bond. And so we would just ask if the court is willing to modify to some sort of PR bond with either like a GPS, substance abuse monitoring, pretrial, any conditions that the court sees fit. That would be the only way that she would be able to post bond. Any monetary bond would essentially be a no bond hold for her at this point. If the court is unwilling, we would just ask for some sort of reduction to give her a better chance, but it is unlikely she'd be able to post anything monetary at this point.
All right, thank you. Ms. Akers, is there anything that you want to tell me regarding bond?
The people would object to a PR bond. I think it's great that she's been accepted into treatment, but we would object to a PR bond just based on the recent history, just so the court's aware. The court's aware, but she was on felony probation in the 24 CR 1624 case. That underlying conviction is an assault with a deadly weapon, a class 4 felony. She was given an opportunity on probation.
I was joking.
While she was on probation for 22 CR 677, that is an underlying aggravated motor vehicle theft. She pled as part of a plea agreement to that as a class 1 misdemeanor. So there is some concern based on just those 2 cases of her ability to remain law-abiding and to follow any kind of court-ordered conditions of bond. There's allegations she couldn't follow the probation conditions. So we would defer to the court on any type of modification or to a cash only or reduction, but we would object to a PR bond.
All right, thank you. So I don't find that a PR bond is appropriate. I do find, I believe on both of the revocation cases, she's currently held without bond. I do find it is appropriate to set bond on those two revocation cases. I'm going to set both the 24 CR case and the 22 CR case with bond at $150, cash only. Conditions of bond will include compliance with all forms of court order community-based supervision, including Ms. Greiner's probationary sentence out of those two cases. It will also be a condition that she not commit any new state, federal, or municipal law violations. With that, Ms. Morris, how would you like to set these?
Yes, Your Honor, we just asked to set for a disposition and hope that we can try to negotiate something.
All right, we'll set this matter out for disposition. What date do we have?
Look at what Pickle said.
April 29th
April 29th at 10:30. Ms. Morris, does that work for you?
Yes, Your Honor.
And Ms. Akers, April 29th at 10:30, does that work for the state?
It does, thank you.
All right, then Ms. Greiner, I'm going to continue this matter over to April 29th at 10:30. That'll be your next court date, ma'am. Thank you.
Thank you.
The court will call 24 CR 909 and 24 CR 908. People of the state of Colorado versus Timothy Mora. Mr. Mora appears today with counsel Ms. Thomas, and Ms. Akers appears today for the state. Ms. Akers, is there any VRE record the state needs to make today?
Your Honor, we are compliant for the hearing today and for the modification in the time, so we're good to go.
All right, thank you. We're set today for trial readiness. I did receive the state's motion to continue the jury trial currently scheduled. Ms. Thomas, any response that you have, why don't you go ahead?
Thank you, Your Honor. My understanding is that our position is that we are objecting to the continuance at this time. Thank you.
All right, and Ms. Akers, can you just briefly lay out, and I can't remember the witness's name, but I believe it's the law enforcement officer involved in the arrest, is that correct?
Yes, Your Honor. So the specific officer, his name is Armando Leyva. The reason he's unavailable, he's out of state on vacation that was previously scheduled. In regards to what I believe his testimony would be, just for the court's consideration, I think I also put this in the motion.
Well, I'm sorry, I do see that.
Okay, and I can put that on the record, but I mean, that's the basis of it. Just for evidence collection, and he did speak with the victim at the scene. So that's the reason for the motion. I understand kind of the posture we're in, and, you know, previously I don't know that anyone foresaw the other trial case that was previously set for the defendant to accept an indeterminate prison sentence over the weekend prior to that case being called on the following Monday. But the people are aware of the somewhat unique posture this case is in. So we did not make this request lightly, but understand that Mr. Mora is in custody, that it was not his request to continue the last trial setting. And so just understanding where we're at, the people made the motion.
Okay, and you said that you were in VRI compliance for that?
Yes, sure.
Okay, and I'm sorry, is the victim here today? I didn't ask. Do we have any victims or victims representatives present? All right, the court doesn't hear a response. Give me just a second here, please.
I really want to drive to the doctors.
All right, here's what I am going to do. I am going to grant the motion to continue, but again, as I've stated previously, I appreciate that this is not Mr. Mora's fault. So, Mr. Mora, what I'm going to do, I'm going to grant the motion to continue. I'm also going to bring you back in for a bond hearing, and I will just let the parties know, given the multiple continuances, going to be hard pressed not to seriously consider a PR bond in this case, but I'm going to try and bring back Mr. Mora as soon as possible so that we can get reasonable VRA to do that. I only have one available setting prior to the expiration of the speedy trial period. I don't find, I know that there was an alternative request to continue it outside of the speedy trial period, but given that I have a setting within that period, I'm not going to address that request. I can tell the parties I have a lot of trials set on April 7th, so I don't exactly know how that is going to shake out, but just so that the parties are aware of that. So the only date that I have would be April 7th at 8:30, and it was set for 4 days, Ms. Akers, is that right?
I believe so, Your Honor.
All right. We'll reset the matter for April 7th at 8:30 for 4 days. And I will also set the matter out for a bond hearing, hopefully this week. With respect to the April 7th setting, do we have a pretrial readiness for that date? March 25th? Okay. March 25th at 1:15 for trial readiness. Ms. Thomas, does that work for you?
Yes, Your Honor, thank you.
And Ms. Akers, March 25th at 1:15 for trial readiness. Does that work for the state?
It does, Your Honor, thank you.
Okay. Let me see. Give me just a second here. Let's do it on Friday at 9:30, and we'll just do this right before we start that prelim. I have time for a hearing on bond. Ms. Thomas, March 14th at 9:30. I think that's Friday. Can you make that work?
Yes, Your Honor, I can make that work.
And Ms. Akers, March 14th at 9:30. Does that work for the state?
Yes, Your Honor.
All right. So, Mr. Mora, those will be the new court dates for your trial and trial readiness, and then I'll bring you back on Friday and we'll talk about bond. All right. Thank you, sir.
Oh, sorry.
All right. The court will call 24 CR 453 and 24 CR 1068, people of the state of Colorado versus Luke Selman. Mr. Selman appears today with counsel, Mr. Duran. Ms. Akers appears today for the state. Mr. Duran, how would you like to proceed?
Thank you, Judge. We do have an agreement in these cases, and we are just waiting on paperwork. I did check with your staff, and it appears we have time on Friday at 11, so we're asking to just come back at that time.
Is that right, the 14th at 11? And Ms. Akers, March 14th at 11, does that give you enough time?
Yes, Your Honor, that will.
All right. Then, Mr. Selman, what I'm going to do, I'm going to set these matters out for another arraignment to March 14th at 11 a.m., and we'll address any agreements at that time, sir.
Yes, sir. Thank you.
All right. Thank you, sir.
Thank you.
Appreciate you.
All right. The court will call 19 CR 2662, people of the state of Colorado versus Adam Trujillo. Mr. Trujillo appears today with counsel. Ms. Thomas and Ms. Akers appears today for the state. I believe Mr. Vassallo is also on the line in this case. Is that correct?
Yes, Your Honor.
Okay. I see Mr. Vassallo appearing remotely as well for the defense. Ms. Akers, is there any VRA record the state needs to make today?
Your Honor, we are compliant for the pretrial readiness today.
All right. Thank you. And did the parties both receive the DHS records that I issued an order on yesterday? Did
Yes,
you
Your Honor, thank you very much.
Ms. Akers, did you get your copy as well?
Yes, Your Honor, thank you.
Okay, that sounds good. All right, we're set today for trial readiness. I did receive a motion to continue the jury trial filed by the defense. Ms. Akers, I know that very briefly the state's position is listed in the motion. Is there any other record the state wishes to make today?
I believe Ms. Thomas put it in the motion, but both the people and the victim's representatives would object to the request, but nothing further to expand upon.
Okay, and I had a couple of questions. Just to make sure that I understand correctly. So with respect to the DHS records, I've just reviewed those. Those seem fairly consistent with the information that I previously received, and it looks like the substantive contacts Detective Finch was also present for, so I presume that most of that stuff has already been documented and discovered to the defense. But what I did want, Ms. Thomas, is can you give me more information about this DNA situation?
Yes, Your Honor.
Sure.
So my understanding is perhaps either in December or January, the prosecution sent off more information to be tested for CBI that had not previously been tested.
Okay.
On Sunday, the people sent us just basically the face sheet of the results of what had been tested came back. And so they let us know that would be coming in discovery in due course. So we just have the face of the results, like yes, no, basically of if he's on there or
None
not.
of the data or anything else
Correct.
associated
We
with
don't
it.
have that. And my understanding is we still don't have that yet. I can see if that's come through yet, but we don't have that yet. So we're still waiting on that to come through with respect to the.
So my main question was, and I think you answered it, but I just want to make sure that I'm clear. This isn't a situation of a retest because of Missy Wood's involvement or anything like that. These were materials that had just been submitted, or just, I guess the results were just received from materials that were submitted.
That's correct. And that was submitted based on the hearing that was done in December. They submitted new things.
Okay.
Yes, and clothing items and things like that. And
Okay. All right. No, that
items.
makes much more sense to me. And Ms. Akers, do you generally agree with that recitation? This wasn't a retest from Missy Woods. These are materials that had been recently submitted and recently received.
Yes, Your Honor, that's my understanding in speaking with Ms. Petrie Beard. And just so the court's aware, we have requested the litigation packet. We have not received that yet. But we've asked for it to be rushed. But I mean, again, noting the circumstances, Ms. Thomas has given the court the correct standing of the case.
Okay, no, I appreciate that. I just needed that additional information. So I certainly appreciate the state's position, and I specifically appreciate the victim's position. This case has been going on quite a while for a number of different reasons that aren't necessarily related. And most of those don't have anything to do with diligence, but I know that this was delayed for quite some period while competency was an issue. Given the very recent receipt of these DNA results and the fact that much of the data behind the results have not yet been received, I don't find that it would be reasonable to force the defendant to proceed at trial without both reviewing that data and potentially arranging for an expert to review that data. I do find it would be unreasonable to expect that occurs in the next 13 days before trial. So I am going to grant the motion to continue once I confirm with Mr. Trujillo the issue of waiving his right to speedy trial. So Mr. Trujillo, your attorney tells me that you wish to continue the jury trial and waive your right to a speedy trial in this case. Is that correct, sir?
Yes, sir.
And Mr. Trujillo, have you had enough time to speak to your attorneys before making that decision today?
I talked to one of them. Miss Thompson was busy
Okay.
at the law firm where they were at, but I did talk to Kyle and he told me.
Okay, you were able to speak to one of your attorneys? And do you need additional time to speak to them before making this decision today?
No,
All right. And is anybody forcing you to make this decision today against your own free will?
no, I'm doing it against my own free will.
So you said you are doing it against your own free will?
Yes, sir.
And Mr. Trujillo, maybe Ms. Thomas, can you get him just a little closer to the microphone? Mr. Trujillo, so I just want to make sure that I understand. So your attorneys are recommending that you continue the jury trial. If you feel like you're getting forced along in doing that, then we can have a conversation about that, but that's probably a conversation we're going to need to have. If you're choosing to do this, if this is something that you want to do so that your attorneys will be more prepared, like I said, I'm always willing, I'm already indicated that I'm willing to grant that request. But at least I'm taking it that you feel like you're forced to do this. Is that?
No, nobody's forcing me.
Oh, no. Okay.
I'm the one doing it for myself.
Okay, I'm sorry. Mr. Trio, I apologize. I must have just misheard you, but based on your answer, I do find that your decision to waive your right to speedy trial is being made knowingly, intelligently, and voluntarily. So I will accept that waiver. I will grant the motion. Today is March 11th. I do find that the new speedy trial deadline in this matter would be September 11th of 2025, absent any objection from either side. We were set for 5 days, Ms. Akers, is that correct?
I believe so, Your Honor.
Okay, and do the parties still believe that to be accurate?
Your Honor, I guess I don't know the facts of the case very well, but considering the new DNA, which may lead to a defense expert, most likely will lead to a defense expert, I think it may go into the 6-day range just to accommodate, at least one more person on the people's side and at least one expert on the defense side. So I know that creates scheduling difficulties to add another day, but I
I can
I'd
tell
rather
you,
be
as I've
safe
learned
than
in this
sorry.
trial, I would rather plan it in and not use the days than
Yeah.
not plan it in and have to reschedule docket. So, Ms. Thomas, do you think 6 days, that's safer?
I think so, and if we wind up not needing it, then that's better than
Okay,
needing
all right,
it.
that's fine. Let's go ahead and reset the matter for jury trial for 6 days. What date do we have? You don't need to come back that soon. Yeah, so Speedy is September 11th, so you can look at June, July, anywhere in there should be good. July 28th for 6 days. Ms. Thomas, does that work for you?
And I apologize, I am just out of the country from the 25th to August 4th. So, and then I'm in a jury trial from August 11th to August 19th. So I can accept anything before or after that. Yeah, that works for.
Just a second. August 25th, Ms. Akers, does that work for you?
Yes, Your Honor, we can accept that.
All right. Then I'll reset the jury trial in this matter to August 25th at 8:30 for 6 days. What's the trial readiness for that date?
August 5th at 1:15.
August 5th at 1:15 for trial readiness. Ms. Thomas, does that work for you?
Yes, that should work for me.
And Ms. Akers, August 5th at 1:15 for trial readiness. Does that work for the state?
Yes, Your Honor.
All right. Then we'll set trial readiness to August 5th at 1:15. Ms. Thomas, at least at this point in time, do you need any other settings besides those?
I don't believe so, Your Honor. And if I could just check with Mr. Vasallo if
Oh.
those dates work, and I apologize, Your Honor.
Mr. Vasallo, does that work for you?
Yes, it does, Your Honor. Both the PTR and the jury trial setting.
Okay, great.
All right, then, Mr. Trujillo, I'm going to continue those matters over to those dates and times. Those are your new jury trial dates, and I will vacate the jury trial set on March 24th. All right, the court will be in a just a brief recess until we start our 10 o'clock case.
Okay, better. I'll see you soon.
So Judge, we don't longer.
Let me look at it, and there's and I'm sorry to interrupt you. They sent me a new
Yes.
thing with, and that new one is probably right. I did forget that. So when you print that
Good
out,
to see you.
I'm gonna run it back just for a second.
So, judge is on a 5-minute break until our sentence hearing starts in about 5 minutes. So, oh, sorry, hang on. So sorry, because there is a Lori Daybell hearing going on right now, and I need to check something if it is being live streamed on something else. 1 second, because I need a feed. Yeah, okay. No, because it's not being live streamed. Yes, yet today. It is. The people are in court and things are moving, but there is no live feed. The judge has not provided a live feed because this motion, one of the motions that is going to be heard in court today, is about the streaming of this trial, about the court TV situation, saying that Lori doesn't want court TV in. So there's already some information. I can tell you guys what the information is, but I don't want to spoil for the hearing that we're gonna hopefully later. By the time we're gonna be on the deliberations, will be already available. Let me know if you want to. Wow. Pickles, that is a lot to juggle at the moment. You okay? I mean, that is a lot to just. No, I'm joking. I do the same too. I get distracted by a notification and then I go into a rabbit hole of that while I was doing 500 other things. But, no, Lori won't be aired live. Nowhere is being aired live, even though Court TV has a stream up saying her hearing. They're not showing anything else, just a place card waiting. But but then later on, LNC is gonna have the video in it, and then we're gonna that wow, and working as well, Pickles, that is amazing. You are amazing doing all of that at the same time. So later on, they should be having the video of the hearing of that. But otherwise, or I can just tell you exactly what happened, because there is already some news coming from the court about this. Just, what? Okay? I see the seal in love. I I don't understand. Okay? Oh, oh, okay. You are 30 minutes behind. Okay, awesome. I was like, huh? You're 30 minutes behind. Nice, awesome. I know. I really am in a kick as well, Pickles. But I'm trying to figure it out which trial is this one, because she has so much stuff going on. What logo? From 30 minutes ago. Ceiling. Oh, Lori Vallow. Okay, you see this. Oh. Oh. Like, you talking to me about. I have so much going on that I was like, hey, huh? You see the seal? Hang on, let me go. Oh, yes, I see the seal too. Ooh. Sorry, I just turned back to the feed on my phone. I got you. Yes. Probably is not. Probably is not. That is the 30-minute delay. Okay, sorry. Yeah. Oh wow, that is a packed courtroom, y'all. This is definitely, get your tissues ready, because apparently this is gonna be a very emotional hearing of sentencing. But don't forget, in about 20 minutes I'm gonna go off. Garden Bot will come in, and then I'll be back with you guys half an hour, 40 minutes, just the time for me to walk down the street to the doctor's center and then back. But I'm gonna have to walk, because I'd said I was not gonna drive that short distance. Oh, apparently this is our defendant, the one in orange, obviously, that's gonna get sentenced today. We don't know anything about this case, almost at all. I think his name is Scott, but if it is not, I don't know anything about it. If it is, I know some stuff about him. It just depends on who he is. So yeah, apparently yes, Lori Dayfollow is on a delay right now, a 30-minute delay. So I think it's already happened, this hearing, but we're gonna catch up to this hearing later on today. So don't worry, we're gonna catch it anyway. We're not gonna lose a second of anything. Almost, I will try not to. And then let's get ready for this hearing.
Worry about it. Just number them straight through.
Oh, and make sure I turn off the mic this time too.
And Ms. Wells, are you ready to proceed?
We are, Your Honor. I have to set up one piece of technology.
Sure.
I'm hoping the court can confirm with defense counsel and I the order in which you handle sentencing, as it may vary between courtrooms.
Sure. So my intent would be, once I confirm everybody's received the PSI and then I've confirmed that I've received all of the mitigating information and other information regarding sentencing, that I have all the information the parties believe I should have. What I would do, Ms. Wells, is allow you to present any witness statements and then hear any sentencing argument from you. Mr. Estel, then I would allow you to present any witness statements and then hear any sentencing argument for you. Does that answer the parties' questions?
That's what I was expecting. Thank you.
It does.
And Ms. Wells, are you otherwise ready to go on record?
Yes, Your Honor.
And Mr. Estel, are you ready as well?
Yes, Judge.
Okay, thank you. All right. I'm sorry. The court is on the record in 24 CR 73, People of the State of Colorado versus Scott Mckee. Mr. Mckee appears today with counsel Mr. Estel. Ms. Wells appears today for the state. We come on today for sentencing. Ms. Wells, is there any VRA record that you need to make generally before we begin?
The victim representatives are present in the courtroom, Your Honor. Several of them will be addressing the court today.
All right, thank you. The court has received and reviewed the pre-sentence investigation report prepared in this case, as well as the community corrections acceptance letter. I've also received sentencing materials from the state consisting of a slideshow presentation as well as several letters that the state has submitted. I have received several sentencing materials, including letters and what appears to the court to be a mental health or psychiatric evaluation submitted by the defense. I do see that there is something currently in my pending filing, so I'm not sure if there's something additional. Oh, it looks like that's regarding restitution. Mr. Estel, is that an accurate recitation of the materials that I should have received from you?
I believe so, and if I don't believe I've seen the restitution that might be pending.
I think I just saw it just moments ago. And Mr. Estel, do you have any additions or corrections to the PSI?
The one thing I just wanted to note, Your Honor, and I did reference it in my sentencing brief, so you may already be aware, but I just wanted to make sure it gets on the record, is the last case that's, or the only real recent case in the criminal record is 23M547, a Boulder County case. And the PSI notes that all charges were dismissed and the case was sealed. I just wanted the court to know that was a case that did not involve Mr. Mckee at all. That's actually the first case I represented him on and how I got to know Mr. Mckee. His brother committed a theft and a criminal mischief and gave his name when he was arrested. Then his brother didn't appear in court. And so a warrant went out for Mr. Mckee for a crime that he was not involved in and that he had no idea had even happened or that he had missed court. I was able to get his identification, review the photos and the body-worn camera from that incident, provide all that to the DA, and that's why that case against him was dismissed and sealed very, very quickly, because it absolutely had nothing to do with him. So, and it's sealed for most purposes, but in here it still shows up, and so I wanted the court to know what had happened there and that that didn't involve him at all.
All right, thank you, Mr. Estel. I appreciate that. Ms. Wells, do you have any additions or corrections to the PSI?
No corrections or additions, and I don't object to defense counsel's record. We would never ask the court to consider sealed cases.
All right, thank you. Then, Ms. Wells, if there's nothing additional, if there are witness statements that the state wishes to present, why don't you go ahead and proceed?
There's a number of those. At first, I have a number of witness statements that I received since our initial submission that I'm going to read out loud. Some of them may elect to come stand by me while I read their statement.
Sure.
Okay. And with the court's permission, the family has asked that I publish Exhibit 1 silently while I read those statements in the background.
That's fine.
His first.
And I'm sorry, Ms. Wells, can you give me just a second? Can you make sure everybody on WebEx is muted and locked, just so that we can minimize any chance for disruption? Okay, all right. I'm sorry, Ms. Wells, go ahead.
You're fine. The first statement would be from Joe Hutchins, the decedent's father. 17 months ago, on October 9th of 2023, my entire life changed forever. I lost my youngest son to a car accident caused by someone else making extremely poor choices. I don't know how to put into words the effect this devastating incident had on my life. The only descriptive words I can find are complete and total devastation and destruction. In other words, life as I knew it came to a complete halt and then disintegrated. That fateful morning, I was forced to watch the love of my life, my wife, literally die inside when we received the news from the Colorado State Patrol that Cody had been killed in a car accident on his way to school. I can still hear the anguished screams and cries for help of a shattered mother who had just lost one of her two children, and I was helpless to do anything to ease her pain. I remember that as I looked into the eyes of my oldest son, Caden, Cody's brother, I saw absolute horror, terror, and disbelief at the loss of not only his little brother, but also his best friend. No spouse nor parent should ever have to witness or experience this degree of pain from their loved ones. So I ask myself, how do I describe this? How will the remnant of my family survive this? I don't have an answer. In the days following Cody's accident, my memories are a little blurry. I do remember sitting in the office of the funeral home making arrangements for Cody's celebration of life, and I was asked by the funeral director what we would like to do with Cody's remains. I remember thinking how barbaric it is for a parent to have decided whether to bury their son in the ground or to burn their son's body. No parent, regardless of age, should ever have to make those choices. I've read that time heals all wounds. Apparently, whoever wrote that has never watched or cared for a mother who lost her son. Since Cody's accident, I have spent my time attempting to console my wife, though I can honestly say that not a day goes by without her shattering throughout the day, grieving and weeping over the loss of her little boy. The negative effects of Cody's death are not limited to our family. The people who are employed by the companies our families own have suffered from Cody's passing. Many knew and worked with Cody and experienced the loss of a very close personal friend, while others were caught in the vacuum created by my extended absence. One aspect that I find absolutely heartbreaking is watching Cody's friends, classmates, and peers try to make sense of this or to understand why Cody is no longer with us. I truly wish I had an answer that would ease the pain I see in their eyes. Unfortunately, I do not. The impact of Cody's death on each member of my family has been absolutely devastating. Dealing with the sudden loss, an immense amount of sorrow and pain has left me crippled in ways I never imagined were possible. As the owner of a towing and recovery business, I have been involved in the recovery of hundreds, if not thousands, of vehicles involved in accidents resulting in fatalities. I'm always deeply disturbed when I see both the physical and emotional carnage and destruction caused from one person's selfish disregard for the safety of others. The results of these poor choices are life-changing for everyone involved, including family of the at-fault party, the victims and their family, as well as the first responders, EMS, and even the tow operators. So along these lines, I would like to point out that 3 days after causing the accident that took Cody's life, one of my employees, Steve Dickinson, spotted and followed Mr. Mckee on Highway 392, where he was horrified to witness Mr. Mckee passing lines of multiple trucks with oncoming traffic having to slow down or pull over to allow him room to pass, all while traveling at speeds well in excess of 95 miles per hour. To me, this is an example of an irresponsible, senseless choices that Mr. Mckee continues to make. This type of behavior needs to stop. My goal in writing this letter is to encourage the court to use the authority granted by the state of Colorado to create consequences severe enough to dissuade this type of reckless behavior and encourage others to drive responsibly. By holding Mr. Meade accountable for his tragic choices, my hope is that another family will be spared the pain that my family has endured and will endure for the rest of time, because unfortunately, there is no probation or parole for my family's sentence. Joe, Cody's dad. The next letter is from Caleb Tornquist. Cody was the best person I had ever met in my life. I first met him at a truck show a few months before he passed, and in that time, he became closer to me than any other friend I have ever known throughout my life. We did everything together, building trucks, putting lights on his trucks, having full build plans of things that we were going to do in the future, and had trips out to Estes Park. I remember the last night I was with him was right before he passed. We were up pretty late talking for hours about close things that we weren't share with others. We had planned to hang out the next day and go out and have dinner and hang out. And that next morning came around. I woke up to text from his family letting me know he had passed away. I was in so much disbelief that I looked at his location and saw that he was left on the side of the road for over 2 hours before his trip to the morgue, where his phone sat for a day or two. It was so hard throughout that day. I sat in my shower and cried for hours. I lost sleep over a week. I couldn't eat or anything. The day after the accident, I pulled myself together for a little while and I drove out to where he had passed. I sat there on the road for 3 hours trying to understand what happened, and I finally realized that he was gone. Tire marks, the violent rolling marks, the big blood puddle, and all of the pieces spread around that field and in that area spanning 50 feet of everything. It was so hard to see that it led me down a dark path for months. I started doubting life and how unfair everything was for such a great kid like him to be so brutally taken away. After finally hearing an update on the guy that ran him off the road, it was over a year. I found out that guy ran him off the road, stopped and took a picture and drove off. This guy does not deserve his freedom, nor should he get leniency. The pain and trauma that this guy caused amongst the community, friends, and family is not fair, and he should have to sit in prison for the rest of his days. After sitting with his mom and talking to her about everything with Cody, I learned even more of how kind-hearted he was, buying clothes for other kids that couldn't afford it, giving homeless people things, just overall helping the community in every way he could. Everybody knew Cody and everybody respected him. I can't think of one person that can say anything bad about him. He was a very outstanding person, and there should be justice for what happened to him. Please do what's right and lock this guy up. Thank you for your time. Caleb Tornquist. The next letter is from Tyson Garcia, who wanted to join me at the podium.
Sure.
And he's changed his mind, so I'm just going to read it.
Okay.
My name is Tyson Garcia, and I want to tell you about Cody and let you get to know him and what kind of person he was. Cody was my best friend in this world. He was such an amazing kid, so full of joy, kindness, and one of the most caring people I've ever met in my life. He was definitely one of a kind. He always put everyone first and would never put anyone down. He would do the total opposite. He would lift people up. He'd make their day better as much as he could, no matter how bad his own day was going. And not just his friends that went for anyone around him. I couldn't even tell you how many times I've been with him and he's brought homeless people things like food, drinks, and even just giving them money. And it's not just homeless people. He would always make sure his friends ate or were included in things, even when they didn't have money. He had the biggest heart for everyone, and he was a hard worker too. Cody was such an inspiration to me on how I wanted to be as a person, even though he was younger than me. I looked up to him so much, and because he was nothing, and I mean nothing but an amazing person, just happiness and joy all the time. He had so much respect and love for everyone too. I spent countless hours, days, months, and years with this kid to where he was like a brother to me. And I've made so many memories with him and have had so many conversations with him of all sorts. And he was always there to come lift me up or just give me time to talk to him and help me through things whenever I needed him. He would drag me to the gym on the days I didn't want to go. He would push me towards my goals and try to make me the best version of myself. That's the type of person Cody was. And now he's gone. He's been taken away from us because someone decided to wake up that day and drive crazy and kill my best friend. Not just my best friend, but someone's child, someone's grandson, someone's brother. I cry so many nights alone looking at videos and pictures and thinking about him all the time. And I wish and wish and wish that I could just talk to him one last time or see him one last time, but I can't because he's gone and it kills me all the time. He was a 17-year-old man with so much of his life ahead of him, but he got his whole life taken away. Let that sink in before you decide how you're going to sentence this man. An innocent child's life was taken, 30 plus years of life gone because of this man, and the max years of life that the man would lose out is 12. But my best friend lost out on his whole life, not just 5 or 10 or 15. His whole life is just gone. So, Judge, I ask that you sentence the man to the maximum possible sentence for his crime, 12 years. I ask that he doesn't get granted time served for the time he's been in jail already. Thank you for taking the time and reading my letter, and I hope you will do the right thing and sentence him to what he deserves. Because my best friend didn't deserve to lose his life, and his family didn't deserve to take this man away from him. His love for God, his friends, and family will be greatly missed. Tyson Garcia. The next letter is from Arnie Thorson. To whom it may concern, my name is Arnie Thorson, and I work for the Weld County Public Works. My job includes the closing and detouring of roads for construction operations within Weld County. On several occasions in the spring and summer of 2023, I witnessed the vehicle that I now know has been identified as belonging to Scott Mckee, who has been convicted for causing an accident involving death. This individual was approaching from the north and then entered my closure without any regard for the posted closure and the barricaded road on County Road 77 and County Road 120. Of these encounters with this individual, he neither slowed down or acted with any concern for myself, the construction closure, or posted detour instructions and proceeded into the construction site at unsafe speeds. At the time, I noticed the manufacturer of the vehicle and he was driving, and I made a mental note of the damage to the front fender of the vehicle as well. This is how I know it was the same vehicle I had observed before. Thank you for your time and consideration. Arnie Thorson, Weld County Public Works. The next statement is from Mr. Kozad, who is a witness in this case. Honorable Judge Vigil. On a normal workday, after vacation, my life was completely turned upside down and changed. In the last year and a half, I've come to know both Cody and the Hutchins family. I would like to appeal to the court to argue for the maximum sentence for the convicted. On October 9th, 2023, I began my workday coming back from an anniversary cruise with my wife. We celebrated a milestone anniversary of 25 years. It was a normal day, except that I was out in the country early as I had no office work to take care of since I'd been gone for the previous week. I was headed out on a normal route to do my job when I encountered the convicted driving down the middle of County Road 100. I cursed him as he took his half out of the middle. I looked at my rearview mirror and to my horror and disbelief, I watched him run a Tahoe off the road. As the Tahoe crested the hill behind me, the person was in the oncoming lane of traffic. The Tahoe swerved to avoid hitting the oncoming car head on. The next seconds of watching the Tahoe roll repeatedly plays like a video in my mind. When I went to check on the driver of the Tahoe, I saw the convicted come back over the hill and then turn around and leave. As I was on the phone with 911 dispatcher, I was working on the young man that I knew there was no point in trying to revive. My life changed in several ways that day, some for the better, some for the worse. I embarked on a journey of meeting a family that not only in my mind is a great family, but did their best to raise a great sons, Caden and Cody, one of which lost their life that day. Since that day, I've learned much about both Cody and his family. The first thing I learned was Cody was a 17-year-old senior at Grover High School and the most upstanding student member of his youth group. I've learned that Cody loved working with and being a role model to younger students. In one instance, his mother, Rochelle, told me that one of the days there was a younger student that was struggling with attention and discipline in class. The student was not cooperative with the teacher or the counselor. Cody was brought into the office as he had been mentoring the student. It took some time, but Cody was able to calm down the student and get him to refocus on his classwork. I've heard that Cody would purposely take a bite out of pizza or whatever dinner was for the night at his youth group so that he would be the one to pray over the meal. It's my understanding that he had very strong Christian convictions and was a leader of his church and his youth group. These are a couple of examples that I have heard Cody of being an example and role model and mentor since meeting the family. Cody was a sportsman, a football player, a farmer, truck driver, and very interested in his family's many businesses. He was involved in the community in which his family lived and worked, from Grover to Alt and Pierce to Greeley down to LaSalle, where the repair business is located. He loved farming with his grandpa and Uncle Clint at their farm near Pierce and relished missing school to help with the wheat harvest. What teenage boy wouldn't want to miss school to run a combine? He was expected to keep his grades up in order to participate in the harvest, and Cody was a typical teenager that loved hunting in the outdoors. Cody was on track to operate a heavy recovery tow truck purchased for him by his family towing business. I don't know any 17-year-olds who are planning to get their CDL at the age of 18 to help others. He was supposed to take on the new truck as soon as he graduated and was excited to be in a position of service to fellow mankind. I bring these traits out in Cody to associate them with my own children. I myself have 2 children that are near the ages of the Hutchins boys. My daughter is now 16 and learning how to drive. My son is a 21-year-old Eagle Scout that his mother and I have tried to instill the same service values in that Cody had. He is between the ages of Caden, Cody's older brother, and Cody. I thank God every day that it was not one of my children that was in that Tahoe that day, but would have traded places with him myself in a second. My own children have their own hopes and dreams of careers and families, and I hope they achieve each and every one of them. The first thing that I did when I left the crash site on October 9th of 2023 was to call my children, both of them. I made sure I told them that I loved them and I wanted to make sure that I saw them at the end of the day. Those were the two most emotional phone calls I've ever had to have. When I arrived at home that night, after continuing to do my job for the day, I hugged and kissed all of my family. This is something that Joe and Rochelle Hutchins will never be able to do with Cody again. Monday, October 9th, 2023 has given me a new appreciation for my own children and changed how I see them forever. This random driver took something from all of us involved that day. From the Hutchins family, he took a son, he took a legacy. Joe and Rochelle now likely have a daughter-in-law that they will never know, grandchildren that will never exist. They will have a loss to their towing and other businesses that is irreplaceable, a partner to leave that to, and all their businesses too. To Dwayne and Janice Brown, they have lost a grandson, as well as an operator and helper with the combine and harvester on their farm. I've not met Joe's parents, but for them, at a minimum, a grandson. For myself, I've lost security in trusting that my own children are that much safer on the roads when they are not in my care. I worry about my own children, even without having to be concerned with having those on the road that have a lack of values for others that the convicted seem to. I implore you to please make sure that this person does not put any other families in the position to experience his lack of value of life as many family and more importantly the Hutchins family has. No parent should have to go through what Joe and Rochelle have. I should not have to worry that my own children will encounter what Cody did. I should not have to write this letter or know Cody and the Hutchins family the way that I do. You, Judge, are in the position to make sure that this does not happen again for a long time to any other families. I write to you about my own family in order to illustrate a point. I was able to return home and hug my children and tell them that I love them. My family is still complete. The Hutchins family has truly and actually suffered a great loss, and are no longer able to do that with Cody. The last love that they were able to express to him was what they were able to tell him that morning before he left for school, fully expecting him to return home safe that afternoon. I have personally seen the outpouring of grief, support, and empathy for this family and their son. His family and friends organized pickup rallies, 2 of which my family and I attended, and even an annual memorial benefit trap shoot that I look forward to participating in the memory of Cody. While I believe that the convicted's true judgment lies with a higher power than all of us, and he will have to answer to God for what he has done, why he did it, there is a responsibility, however, to make sure that everything in mortal power is done to keep from repeating the same mistakes. Some would argue that 12 years is not long enough. I don't disagree. I would like to argue that it should be for as long as the law allows. As the one who firsthand tried to do what I could for this family to help their son, brother, grandson, I strongly encourage you to bring the full sentence to the convicted. Force him to take responsibility for his actions and lack of personal convictions. Thank you, Jeff Kozad. And then the final letter that I will be reading is from Caden Hutchins, the decedent's brother. My name is Caden Hutchins, and Cody is my little brother. Cody and I grew up on a farm, and growing up, we were always together. There were so many things we did together, from riding four-wheelers, driving wheat trucks, working cattle, or hunting. We were brothers, but we were also best friends. If one of us didn't think of something, then the other one did. And sometimes one or both of us would get into trouble, but we had fun. We also had each other's backs. That's what brothers do. And now I no longer have my brother as part of my life. And it's hard to express in words how much the pain of losing Cody has affected me. I've lost that one person I could talk to or just hang out with. Cody and I had so many plans for the future when he graduated from high school, a future that included working together at our family towing business, hunting, working out at the gym. But on October 9th, 2023, that was all taken from me as the result of one person's careless actions. Am I mad? Yes, I am. Am I angry? Yes, I am. And the careless actions of one individual has taken so much away from me, my mom, and my dad. My parents find it difficult coming to work each day because Cody's gone. One of his many plans following high school graduation was to work with and become a bigger part of our family businesses. That can no longer happen. The devastation our family feels because of Cody's absence is difficult to explain. It breaks my heart to see my mom cry every day because she no longer has Cody in her life. It's also hard to see my dad struggle every day as he tries to help my mom, but also as he tries to work through his own grief. The future of our family and of our family businesses changed the day we lost Cody. As a person who has worked many vehicle accidents as a tow truck driver, I've seen the devastation that can happen as a result of someone's careless actions when they were driving. We all carry the same responsibility when driving a car. When someone chooses to drive a vehicle in a manner that endangers others or takes the life of someone, they should be punished for their actions. And that is what I'm asking for today. Punishment to the fullest extent of the law for taking my brother's life. I can't have my brother back. I can't do the things with him that we had planned to do together. I felt robbed. Those future plans will not be part of my life anymore. They are gone. We shouldn't be here today in this courtroom, but we are, and it's because of the careless actions and total disregard for another person's life that we are here. Your Honor, please consider the devastation my family has felt from losing Cody. This is something we will never be able to get over. Thank you. Caden Hutchins. Next, addressing the court will be Janice Brown.
And Ms. Wells, before you do, can I have those letters, please?
Yes.
And Ms. Brown, if you'll come up, if you'll give me just a second, ma'am, to organize these letters, and then I'll let you speak.
They're in the order I read them.
All right, thank you. And Ms. Brown, you can go ahead and come up, please. So, Ms. Brown, before you begin, if you could please state your full name and spell your last name for the record, and then I'm happy to consider anything that you'd like to tell me.
Okay, thank you, Your Honor. My name is Janice Brown, B-R-O-W-N,
All right, thank you, ma'am. Go ahead.
and I'm Cody's grandmother. Deciding what I wanted to say today has been a struggle, and it's been really hard to put into words about how losing my grandson has impacted my life. Your Honor, what happened the morning of October 9th, 2023 changed my life forever. We only had Cody for 17 years and 8 months. This was a kid who loved life and who loved being around people and who loved wanting to make everyone's life better. He was a friend to everyone. Cody was always at my house looking for something to eat, asking for help with his homework, or just wanting to talk. Those memories cannot be taken from me. However, I can no longer make more memories with Cody, nor can I take joy in watching Cody grow up into the man I knew he could be, or to see what he would have done with his life. That was all taken from me, and I can never get that back. I miss everything about Cody, his huge personality, his kindness, his respect, his relentless teasing, his orneriness, his sense of humor, his blue eyes, his curly blonde hair, his smiles, and his big hugs. But what I miss most of all is Cody's love. Cody never wavered from showing you how much he loved you. My grandkids call me Lala. Cody would always end his phone conversations with, "Love you, La." Or when he left the house, he would always thank me for feeding him or helping him. And he'd yell out as he was heading out the door, "Love you, La." That was Cody. Now, all of that has been taken away from me, and I don't get to hear him say those words to me any longer. Cody had a big heart and was always looking for the next adventure. There was always something he was looking forward to do. I still find myself looking out my kitchen window waiting for Cody to drive up in his pickup. And now I have to accept the fact that that will never happen again. Losing Cody has left a huge hole in my heart, a hole that will always be there and it will never heal. It's hard to find the words to explain the hurt and anger I feel because Cody is gone. A grandparent is not supposed to bury their grandchild. That's not how life is supposed to be. But yet, I've had to do just that. One individual's carelessness and lack of total disregard for human life took so much for me that morning. I've attended every court appearance for this case, both in Judge Kern's courtroom and this courtroom, and never once did I see the defendant show any remorse for what happened. I don't think he understands the impact his actions have had on myself, my family, and Cody's friends. We don't get Cody back, and we have to live with that pain and realization every day. I would like to share something that I read just a few days after we lost Cody. You don't just lose someone once, you lose them over and over, sometimes many times a day. When the loss, momentarily forgotten, creeps up and strikes you from behind, fresh waves of grief crash in as the realization hits home. He is gone again. You don't just lose someone once, you lose them every time you open your eyes to a new dawn. As you awaken, so does your memory, and with it, the jolting bolt of lightning that tears through your heart, reminding you he is gone again. Losing someone is not a single event, it's a journey. There is no end to the loss, there is only the learned skill of staying afloat when the waves wash over you. As you face that journey ahead of you, there is a daily shock to the system as you realize once more he is gone again. You don't lose someone once, you lose them every day for a lifetime. I lose Cody every day, and on some days I lose him more than once. That is what is so hard. Please, Your Honor, remember Cody and the joy, laughter, and fun and love that he brought not only to me and his papa, but to so many other people. He should still be here sharing that joy with us. Thank you.
All right, thank you, Ms. Brown. All right, Ms. Waska.
The next will be Clint Brown.
All right, thank you. Mr. Brown, if you can come up to the microphone, sir. And Mr. Brown, again, if you can begin by stating your full name and spelling your last name for the record, since we record all of these proceedings, and then I'm happy to consider anything that you'd like to tell me.
Clint Brown, last name Brown, B-R-O-W-N.
All right, thank you, sir. Go ahead.
I'm Cody's uncle. Thank you, Your Honor, for allowing me to speak today in your courtroom, first and foremost. As you've heard previous statements that have both been read and that my mom had talked about, Cody was an amazing person. Cody had love for life. Cody had love for people. Cody had love for hunting. Cody had love for animals. Cody was just one of those kids that was wiser and older beyond his physical years. There are many, many stories that we can sit here and tell you about who Cody was, what he offered to society, what he did for other people. I'm going to give you a quick one. The day before Cody passed, I was up at my parents' house. My two daughters, at the ages of 9 and 7, were up there as well. They were interacting with Cody. They loved Cody. They loved to play around with him. Cody had a kind heart. Cody would show him, joking with him and really, being a good person to him. He would always try and give him stuff. He would always try and play with him, throw water balloons at him, whatever it may be. That was the last time my daughters got to see Cody. Cody was coming into himself as a man. Cody was just figuring out who he was. Cody had a couple years in there where we didn't know what he was going to do. If he wanted to be a welder, if he wanted to be a farmer, if he wanted to be a tow truck driver. But about the age of 16, 17, we realized that he was going to be whatever Cody wanted to be. And we were so looking forward to seeing who Cody was going to be as he grew up. He would tell us the story the day before he passed about taking a trip to a pumpkin patch. His friends and him had gone there, and a couple of them couldn't afford to actually get into the pumpkin patch. And he said, you know what? It's fine. I got you guys. I'll pay for it. It's not a big deal. There's not very many 17-year-olds that can fork over $200 for their friends to get into a pumpkin patch. But that's who Cody was. Cody wanted to include everybody. Cody wanted everybody to have a good time. Cody was not the life of the party. Cody was the person that made sure the party was safe and made sure everybody had a good time at the party. And that party could have been, as you saw, driving a lawnmower in our shop, or being out at wheat harvest, or being at school, or with his youth group, or with his shooting group that he did. He made an impression on every single person he touched. That includes the sheriffs and the state patrol that showed up at his funeral that day that we had to bury him. The problem is there's no more memories that we get to have with him. There's only previous memories. There's no new ones. There's no new pictures. Half of the pictures that were shown up here were ones that I took of him. It's hard to think that there's a finale on how many memories that we got to make with Cody. I never thought I'd ever have to say that. The man sitting next to me who was convicted will come up here and give his allocation statement. He'll talk about accountability. He'll talk about responsibility. He'll talk about remorse. He has not taken accountability for his actions yet. He has not showed remorse for the pain that he's caused us. Judging by his previous record, he is not a responsible person to be in our society. He never took the stand. He had the opportunity to. He still claims his innocence. There are questions that still are unanswered by our family. Why did you swerve into oncoming traffic? What was distracting you? Why didn't you stop to help? Why did you later stop and take a picture of what you caused? Why did you not take the plea deal and admit your guilt? Why did you make our family sit here through the court proceedings and have to relive every single part of that day? We relive it every single day. We don't want to sit here and look at pictures. We don't want to sit here and wonder if Cody would have been fine if he would have just taken a few more minutes before he left that morning. Those are all things that we wish we could answer those questions, but we can't. There's one person that can answer those questions, and he has yet to speak on why some of that happened. He's not fit to be a free man in our society until he has paid for what he has done. A quote by Albert Einstein is, with every action, there's an equal and opposite reaction. With every problem, there's a solution. Just a matter of taking action. I ask that you look at the totality of this case and what happened, and I ask that you take action and give Cody some justice. Thank you.
All right. Thank you, Mr. Brown. All right. Ms. Wells, go ahead.
Next will be Brenda Hahn.
All right. Thank you. Thank you, ma'am. If you'll come up to the podium. And ma'am, again, if you'll please state your full name and spell your last name for the record, and then I'm happy to consider
Yes.
anything that you'd like to tell me.
Dr. Brenda Hahn, Haun.
All right, go ahead, ma'am.
Your Honor, members of the court, family, and friends. My name is Dr. Hahn. I'm a mother, a grandmother, a rancher's wife, a veterinarian, a youth group leader, and a business owner. I have known Cody's family since before he was born. Cody's grandmother Janice was a secretary to the dean of the CSU College of Veterinary Medicine Biomedical Sciences for many years, including the 4 years I was a vet student. This is when I first became acquainted with the Brown Hutchins families in 1990. Janice and I became friends, and she asked me to be their veterinarian upon graduation from CSU's vet school. That began a long and lasting relationship between our families. My son Cash and Cody became friends at an early age. When I would make house calls for animal care, or the family would bring animals to my clinic, Cash and Cody would have a great time as young boys playing. The year Cody started 8th grade, his parents enrolled him at Pawnee School in Grover, where Cash attended school, and I was a member of the school board. Cody quickly developed a tight network of friends he had a great deal in common with. Although I had known Cody for years, it was at this point that I really got to know him, because not only did I get to see him often at school and sports activities, but as a youth group leader of the Friendship Alliance Church in Grover, I came to know his heart as Cody attended the youth group that I taught. Cody was a rough and tumble, happy, mischievous young man with a heart as big as Texas. The surprising thing to me regarding Cody was that he was fiercely spiritual. He understood his relationship with God, he understood the Bible, and he had favorite scripture. It was such a joy to have Cody in youth group because despite his energy and his bigger-than-life personality, which anyone who knew him could attest to, he took his belief in God seriously. After youth group on Wednesday evenings, Cody would often ride home with Cash and me and have dinner with our family before his parents or brother would pick him up from our house. He was so at ease at our house, like he was meant to be there as part of our family. I never had to ask Cody if he wanted seconds because he would just get up and go help himself, which was just Cody. And I loved that he was so comfortable with us that it was like a second home for him. Besides being a great eater, he would also start cleaning up plates in the kitchen without being asked because that's just who he was. He was smart, he was ambitious, responsible, kind, loving, athletic. He loved life, he loved his family, he loved his friends, he loved his animals. Honestly, I don't know too many people, especially at Cody's age, who could call so many people their friends. He had friends all across northeastern Colorado. Cody was all boy. He loved hunting and fishing, he loved trap shooting, he loved football, he loved most sports, he loved his pickup, he loved truck rallies. He was a loyal friend. The hole left in people's hearts and lives when Cody left this physical earth is impossible to describe. I will never forget. Oh, I will never forget the morning. As a school board member, I received a message from Mr. Robinson, our superintendent at Pawnee School, that we had lost a student. He did not give any details, but suggested the board members come to the school right away. I knew if our school lost a student, it was going to be tragic for everybody at our school because we have such a small, close-knit school. I dropped everything and drove immediately to the school and was met by Mr. Robinson. He knew how much I cared for Cody, and he wanted to stop me in the foyer to tell me it was Cody that we lost before I entered the school building because he knew how impossible it would be for me to hear the news. My son Cash, who's great friends with Cody, has not been the same. Not only did he lose one of his best friends, but Cody passed on Cash's birthday. The emotional, mental, and spiritual struggles Cash has faced since October 9th, 2023 are indescribable, bordering sometimes as insurmountable. His life has changed forever. Almost every struggle that my son has had to deal with since Cody's death, October 9th, 2023, traces back to the loss of his friend. There is no fix for that kind of emotional trauma. And for the young people who consider Cody a great friend, they have been robbed of their joy in their normal high school experiences. These young people have had so much grief to deal with since Cody's passing that much of their high school years have been a blur for them. I know firsthand the struggles these young people have suffered through, and they still struggle through. Cody's death will never leave them. Cody's immediate family, his mom, his dad, his brother Caden, his grandparents, have suffered so much trying to keep their lives moving forward without Cody. For much of the time since Cody's passing, there has been no forward motion, just trying to survive one day at a time, 1 hour at a time. As friends of the family, we have tried to console and support, but the bottom line is we can't make this better. We can only hope to make fragments of time more bearable. My husband, being very fond of Cody's family, and especially Cody, told me recently that he will never be the same either. A part of him died when Cody died. I believe that everyone who truly knew Cody feels the same way. A part of us died that day, October 9, 2023, the day this man decided to drive recklessly with no regard for anyone except his own selfish needs. Cody was the exact opposite of this person. Cody gave his heart and love to those who knew him, and that is why he had so many friends all across northeastern Colorado. Cody had big dreams and goals. He used to share his future plans with me. He was so excited for life. Being a part of the small communities of Grover and Hereford, I know things about this individual being sentenced today that the court and the jury were not allowed to hear. The maximum time allowed in the strictest of terms will never be enough to rectify the loss of Cody. Cody had the potential to change the world in the most unimaginable way. Cody Hutchins was a light to the world. God will deal with this man's soul, but the legal system has a responsibility to remove him from society for as long as possible, to prevent other families and friends from enduring the unending heartaches caused by his irresponsible, reckless behavior with no regard for human life. Thank you, Your Honor.
Thank you, Doctor. All right, Ms. Wells, go ahead.
The next will be Janelle Robinson.
Thank you. Ms. Robinson, if you'll please come up to the microphone here, just right up here. And ma'am, before you begin, again, if you could please just say your full name and then spell your last name for the record.
Janelle Robinson, Robinson.
All right, thank you, ma'am. Go ahead.
Good morning, Your Honor.
Good morning.
My name is Janelle Robinson, and I work at the Pawnee School where Cody went to school. I have known Cody since he started the 2019 school year. I was Cody's bus driver until he started to drive himself. I was also one of the cooks who served him lunch every day. I have to say I have never met such an amazing young man. He was such a polite, honest, and caring kid. He had a smile that would light up a room. He was so full of life in everything that he did. He was such a giving young man who cared for others as well. And you just don't see that anymore in kids these days. I have witnessed him buying things for kids in our school who didn't have something but needed it. And it wasn't just certain kids, but all of them. After Cody's passing, I started what I call Cody's Closet. It's in a little spare room in our school. It is stocked with basic necessities, plus more items that our students might need. For example, jeans, shirts, gym shorts, socks, undergarments, gloves, boots, etc. And also, I have stocked food items for those students that are easy prep meals for kids, and toothbrush, toothpaste, body wash, etc. I did this to honor Cody because, like I said before, he was such a caring and giving young man. And I wanted to keep that going for him. We all miss him so incredibly much. His life was taken way too soon and in such a reckless and careless manner. And from someone who has no regard for human life. And the evidence shown in the trial, knowing that he just caused a terrible accident, he should have went back to see if he was okay or even try to help. It shouldn't have mattered if someone else was already there. Anyone with a conscience would have. And to take pictures after that and just leave? What kind of being would do that? This guy has shown no remorse for what he has done to Cody, his family, and all of us and his friends. This guy has taken away precious time from his family that they will never have or get back. Cody will never get the chance to go to his high school graduation, have a career, get married, or have a family of his own. So with all due respect, Your Honor, we are counting on you to do what is right. Do not give this being another chance to go out and hurt or kill someone else. Next time it may be a family. I would like to end with Cody was a very trusting person. And it shows, which in these blue wristbands that we had made, his verse that he always went to, which is, God has got this. Thank you, Your Honor.
Thank you, ma'am.
Next will be Stephen Hadley.
All right, thank you. Sir, if you can please come forward to the microphone. Mr. Hadley, give me just a second. Ms. Wells, we have a Jody Hooper that's been trying to get onto WebEx. Are you aware if that's someone observing? Unfortunately, due to the disruptors, we have to be very selective on who we let in. Is that, Mr. Estel, is that a family member of Ms.?
It sounds like it's his aunt.
Okay.
So yes, that should be let in.
We'll, if you see them, you can let them in.
Thank you.
I'm sorry, Mr. Hadley, for the interruption. Again, sir, if you'll please just state your full name and spell your last name, and then I'm happy to consider anything that you'd like.
Stephen Hadley, Hadley.
All right, go ahead, sir.
Cody Hutchins, where do I even start? As I'm sure by the time you got to this letter, you have read dozens of others just like it, and it is my hope that you have not become complacent in reading about how important our late friend and family member is to us because of how little you know about him. To us, he was everything. I did not know Cody for a very long time, but in the few years that I had the pleasure of his company, he had a massive impact on my life. He was so bright and full of life, it was hard not to want to be around him. From practically the moment we met, Cody and I were attached at the hip. From working, hunting, fishing, camping, hiking, to even just sitting around on the weekend, planning what adventure we were going to go on next. For a kid of his age, he had impressively big plans and was a vacuum for knowledge. I remember the first time Cody came camping with me like it was yesterday. I was planning a multi-day fishing camping trip up to Red Feather Lakes in the summer of 2022. It had gotten around the shop what I was doing, and before too long, Cody was asking if he could join. Of course, I said he could, and not knowing anything about fly fishing, he went out and bought everything he thought he would need for a long weekend on the water. Chomping at the bit, he had a list of questions for me every time we saw each other, from what he should expect, what he should pack, and if there would be bears. I cannot forget the light in his eyes and the joy he expressed when we got up to camp and he caught his first fish on the fly. Cody was elated with his accomplishment, and I swear he thanked me 200 times for letting him join on this adventure. I think that is where Cody and I bonded and became inseparable. There is not a single outing from there on out he wasn't asking to join. That was just Cody. He had a love for the outdoors and wanted to soak up any kind of knowledge or new experience he could. The next fall, when goose season started, Cody had the opportunity to share with me his knowledge of waterfowl and dragged me out every opportunity we had to go shoot geese, and it was the most fun I had ever had. We hunted 2 seasons together, and since I have not gone on a single one without thinking about him. It will never be the same. Cody Hutchins impacted so many people in the way he did me, and I truly believe he was 1 in a million human. I never met a single person who spoke bad about him or had a negative outlook on him. It is an absolute travesty that Cody was taken away from us, and when I heard the news, it was devastating. I could go on and on about stories we had together and plans he had for the future, but the unfortunate reality is none of them will come to fruition. He has been unfairly taken away, and I'm sure that somewhere up there, he is picking someone's brain about hunting or fishing spots and when the best time to go is. Cody Hutchins has been and will continue to be truly missed. Thank you.
sir. All right, Ms. Wells, go ahead.
Christina Jensen.
All right, thank you. Thank you. Ms. Jensen, if you'll come up to the microphone. And again, ma'am, before you begin, if you'll please just state your full name and spell your last name for the record.
My name is Christina Jensen, Jensen. I've literally known Cody since the day he was born. I babysat Caden, Cody's older brother, then Cody after he was born. Cody was the first baby that I had the privilege of caring for. To say Cody's death was a huge loss would be a colossal understatement. I really struggled when I was asked to speak today. What can I say in a few minutes to make you understand what is missing from the world without Cody Hutchins in it? How do you adequately explain what is missing from his family, friends, and community? I could tell you about the blonde-haired baby that taught me so much. I could tell you about the teenage boy whose smile could light up a room. The boy who was always making sure to include kids that were less fortunate than him. I could tell you about the hardworking young man he was becoming. I do not think I will. I believe that you will get that from everyone else speaking today. I will tell you what I have seen in the past 17 months. In the months since Cody's tragic accident, I have personally witnessed so much. I have watched one of the strongest, most independent women I know become a shell of herself. A smart, strong-willed, independent business owner become crippled with grief. Cody's mom, Rochelle, has struggled to deal with the loss of her youngest son. No one can imagine the heartache she is going through. I have watched Caden, Cody's older brother, struggle to keep his faith. He struggles every day with loneliness and anger from the loss of his brother and best friend. I have watched Joe, Cody's dad, cling tight to his faith and do his absolute best to prop up his precious family. I have watched a family that I admire for so much of my life struggle not only mentally but physically. This has not only taken a toll on their mental well-being, but their physical health as well. I have seen the way grief and pain has tried to weasel its way into a family and pick at the edges left raw by the missing member. I have held my own 2 sons while they try to understand the loss of their friend. I sat in this courtroom with Cody's dad, mom, and grandparents during Mr. Mckee's trial. Mr. Mckee sat in his chair showing no remorse for his actions or empathy for the situation he caused. Mr. Mckee has an extensive record showing that this is not the first time he has had disregard for the law. It is clear the consequences in the past have not made an impact on him. The body cam footage shown during the trial, Mr. Mckee told Trooper Lewis that he would have been dead if that guy had not moved over. He knew there had been an accident. Mr. Mckee came back, took a photo, admits to sending it to his girlfriend, and left. What Mr. Mckee did not do was follow the general rules of society and attempt to render aid or stay and take responsibility for his actions. Mr. Mckee obviously does not think that the general rules of society or the law apply to him. There is no sentencing that can right the wrong that has been done. There is nothing the court can do to bring Cody back to his family. However, I would encourage the court to punish Mr. Mckee to the fullest extent allowed by law. I would hope that some time spent in the DOC would make Mr. Mckee understand that there are consequences for his actions and possibly save another family from the same heartache.
All right, thank you, ma'am. I appreciate you being here today. Ms. Wells, go ahead.
Next will be Brett Robinson.
All right, thank you. Thank you, sir. If you can come forward just to the microphone. And again, sir, if you could start by stating your full name for the record and spelling your last name, and then I'm happy to consider anything that you'd like to tell me.
I'm Brett Robinson, Robinson.
All right, thank you, sir. Go ahead.
I serve as the superintendent of the school district in Grover, where Cody attended school for 5 years. I was also Cody's science teacher and clay target team coach. I am the person who had to call counselors to the school and put together an all-school assembly for the staff and students to tell them that their senior classmate and student had been killed on his way to school. Because we are a school family out in Grover, you can imagine how difficult this was for all of us, and a definite low point in my career of over 30 years working with families and students. Cody was a light, and he did not hide it. He had many positive characteristics, and some were just developing as his life was cut short at just 17 years old. In that time, he affected many people, as you have heard. One quick story I will tell as a testament to his character happened a few years ago. He walked into my office and he handed me a wad of cash. You see, the clay target team had ordered some special hoodies with our logos on them, and they were not cheap. He went on to say he had just cashed his paycheck. He had a job and he worked when he was not in school, and he wanted to pay for his hoodie and 2 other students who he knew could not afford them. Said, "Don't tell them who paid," and he walked out. What kind of 16-year-old does this? I found out later his parents were unaware of this generosity, and many others I learned about later involving a meal, a ride, or whatever he thought somebody needed. He was a young man who was making a difference and had the potential to make the world a better place. Instead, on his way to school to start a week, he had all planned out with turning in his homework and attending his senior homecoming and hunting with his dad on the weekend, all normal kid things. He was faced with a decision no adult should have to make. In a second of time, he had to choose between having a head-on collision with a stranger in his lane, surely resulting in 1 or more fatalities, or swerving to the opposite ditch, hoping he would be able to recover. Greater love has no man than to lay down his life for a friend. And Cody did it at 17 for a stranger. Cody became one of my heroes on that horrid morning in October 2023. Cody was not killed in an accident because the car wreck could have been prevented. The jury in this case found the defendant guilty on both felonies he was charged with, followed by a revocation of bond by you, Your Honor. When it comes to sentencing, we should talk about the importance of the word time. Ecclesiastes chapter 3 has a lot to say about time. There is a time to mourn, a time to laugh, a time for silence, and a time to speak out. There is nothing better for people than to be happy and do good while they live. That is what Cody did. It also says God will bring judgment to both the righteous and the wicked. There'll be a time for every activity and a time to judge every deed. The defendant in this case has manipulated all of our time in this crime, yours, mine, the jury members, the district attorney's office, everybody involved for way too long, playing games with plea agreements and conflicting statements. Try and not be judged, held accountable, accept or admit what he knew he did the whole time. He left the scene like a coward, and he cried when he finally got caught. All this time pales in comparison to the time Cody's family has lost. I said there was a time for every activity under the sun. A lifetime of activities was stolen by wickedness in this case. The time of competing at the national championship on a team that lost a member, the time of graduation and celebration, the time of driving his new tow truck and working for the family business that he loved, the time of dating, the girls loved him, marriage, children, grandchildren, his passion of hunting and fishing, a career, a lifetime of memories. He would have been a dynamic leader in our world. As a school person, I have known hundreds of students well. And Cody had what we all want for our youth. I said this many times at school, and I mean it in depth, that we all needed Cody more than he needed us. His death sentence and the life sentence inflicted by the defendant's carelessness on the Hutchins family and Cody's friends is forever. Every activity that would have happened during this time cannot go unpunished. This defendant is not a first-time offender, but has had enough legal infractions to know how to work the system to receive light punishments from previous judges. Perhaps if more strict, responsible punishment had been given in the past, Cody's life would not have been taken. Only strong justice moving forward today will ensure another family does not lose a lifetime. You have the authority to manage time for this defendant. His lack of remorse, personal responsibility, conscience, respect for the law, rules, and life make him a danger to society, and I would ask for his sentence to be the maximum allowable by the law, incarcerated, and not on some probation program, which can be played like another game. This will not bring Cody back, but it is time for judgment and justice that will protect the rest of society and give purpose to those of us creating programs like Cody's Closet and the Cody Hutchins Opportunity Memorial Fund in his name to carry on what he would have been doing if he would have had the time. Thank you for your consideration.
Thank you, Superintendent. Ms.
Todd,
Wells, go ahead.
thank you. Todd Pembroke.
All right, thank you. Thank you. Mr. Pembroke, if you can come up to the microphone. And sir, again, if you could please state your full name and spell your
That's
last
Todd
name.
Pembroke, last name Pembroke.
All right, thank you, sir. Go ahead.
Thank you, Your Honor, for allowing us to do this today. Anybody who knows me knows that I can speak and I can preach for a long time, but you've heard a lot already. I'll keep it brief. I am Todd Pembroke. I am the pastor of Friendship Alliance Church in Grover. I'm Cody's pastor and friend. Did I say am? Because he is home with Jesus because of his faith, and I get to see him again. We all do. Who know Jesus will see him again. But until then, I battle the pain of an unmanageable loss. You know, I was family to him and to his family. He was a friend and classmate to my son, Donovan. Cody came to our house on numerous occasions, and you've heard numerous stories. I could tell you so many stories about Cody and his just amazing. He was respectful. He was outgoing. He was funny. He would walk in a room, and I would just, whether it was at our house, at the church, youth group, whatever it was, I would instantly smile. You couldn't help but just smile when he came into a room. I have a hard time as a pastor explaining to Donovan, to Cash, to all these kids, a lot of these kids that are behind me, that were his classmates and friends. I have a hard time, even as a pastor, trying to tell them and explain to them and help them understand why this happened. I, quite frankly, don't know myself. Only God knows. This is Cody's mom. Rochelle told me as we were planning Cody's celebration of life, she said, Cody wasn't perfect, but he was amazing. And that sticks to me. I think of that every day, that I want somebody to say that to me about me someday. I want that to be said to all my children, my grandchildren, my friends. No, there's no greater compliment. Cody's celebration of life was amazing. There was, I think, 600 to 700 people there, and so many more could have. It was just an amazing day. But I have officiated many funerals and celebrations of life. That was the hardest, the absolute hardest. We've had a lot of loss in our community over the last few years, and but that day when on October 9th when Brett Robinson called me to come in, because that's the kind of community we are. The church and the school and everyone in that community just works together and sticks together. And he called me in, and again, like Brenda had said, he had told me, he didn't give me any details. So many things were running through my head, because I knew a lot of the boys that drove themselves to school. And when I got there and it was Cody, I just fell to my knee. I just buckled. You know, it takes a lot to knock me down. And again, when people started coming in, like Brenda and different people coming in and the school counselor, it's just still surreal to me that this happened. He had this infectious smile and this big personality, and this world is so different and worse off for him being gone. I miss him so much. I've walked along the side of the family as their pastor and even as a CPA to help them with their business, to help keep things going. I see them just about every day, or talk to them, or pray with them. And it is 17 months. There's no, someone mentioned that time heals all wounds. They're wrong. It doesn't. There's nothing that will ever heal that wound. As his pastor and co-youth group leader with Brenda, I knew a young man who loved the Lord and lived his life accordingly. So many people talk it, but they don't walk it. Cody walked it. He was a natural leader, especially we've heard this to the younger boys and girls at the Pawnee School, and we also used to call him the Pied Piper, because the little kids would just follow him around, and it was amazing. And my wife, Tina, she's the kindergarten and preschool teacher at the school. And so she saw that a lot. She got to see Cody come into her classroom, or just walk through the hallways, or be in the cafeteria, and those kids just flocked to him. It's just, you didn't see anything like that. And I know it's easy for us to stand up here and just say all these great things, but in this case, it's true. Cody's life was cut short by the actions of another person, and that person, I believe, deserves punishment to the greatest extent of man's laws. You've heard it from a few other people. I'm not going to preach, but the ultimate punishment is that when he stands in front of the highest judge, no offense to you, sir, there is a higher judge. From everything I see and hear, there's no remorse or regret other than that the guilty party got caught, as so often happens. So I'm pleading with you to remove this man from society for as long as you legally can, to save the next Cody, and to have ample opportunity to contemplate what he's done. I thank you for your time, Judge.
All right, thank you, Pastor. Ms. Wells, go ahead.
And the final witness to be addressing the court will be Rochelle Hutchins, the
All right.
mother.
Okay, thank you. Thank you. Ma'am, if you'll please come forward. And Ms. Hutchins, if you'll please state your full name and spell your last name, please.
My name is Rochelle Hutchins,
Right.
and my last name is spelled Hutchins, and I am Cody's mom.
All right, thank you, ma'am. Go ahead.
I am standing before you today because my youngest son, Cody, is no longer on this earth. Just saying those words are unfathomable, unimaginable, and something I have not and cannot come to terms with. I am in complete shock and disbelief at where my life has gone and what path it has taken. There are no words to adequately describe losing a child or the pain that goes with it. Unless you have experienced it, you truly have no idea what I am talking about. The weight and the pressure to say the right thing or not forget something or let your child down is so overwhelming. How do you describe your child, your own pain, and the brokenness of your family in minutes and in front of a whole courtroom full of people? It forces me to face something I don't want to face and realize something I don't want to realize, because my heart has been destroyed and my world completely devastated and shattered. The wound will never heal and there will never be a scar, because my heart keeps getting torn open every single day. Cody has bright blue eyes, blonde hair complete with curls, a perfect smile, and is all boy, a true farm kid. On the farm, kids start driving at an early age, and this was no exception for my sons. Cody started driving four-wheelers and razors by age 5, and there was never a time there wasn't a German Shepherd in tow. I've included a few of those pictures on the slideshow. By age 10, he was driving semis, backhoes, skid steers, and loaders. He loved operating heavy machinery and soaked it all in, just like his big brother. During wheat harvest, he usually drove a semi, but he decided he mastered semis and wanted to start driving combines. Cody was a natural at driving combines as well. For those of you that aren't familiar with combines, that too was in the slideshow. When Cody got his driver's license, he would take the pickup and stock trailer and haul cattle to Wyoming and Nebraska by himself. He always had a trailer in tow, whether it was hauling hay or equipment to our ranch. Cody grew up on dirt roads, and most of his experience stemmed from dirt roads, the true meaning of boys and their toys, and he had so much experience at such an early age, and he took great pride in that. He was so responsible, hardworking, respectful, quick to make you laugh, a definite mama's boy, and had such a big heart. He had so many passions, but the most important were his family, his faith, hunting and fishing, football and shooting sports, and his pickup. His hugs were so genuine. He was 6'1" and wouldn't let me forget it, especially when he would give me hugs. He would wrap me in his arms and made sure I knew that I only came up to his chest. Cody was my mini-me and had that ornery streak, so he definitely knew how to press my buttons, but to me, he was perfectly imperfect. One weekend, Cody had a lot of homework, which he wasn't super thrilled to be doing. After all, this was his senior year, and senioritis hit Cody pretty hard in September. He asked me what I was doing that day. I told him going to work, of course. He asked me if I was going to be in the dispatch office, and I told him I was. He asked if he could bring his homework and sit at the other computer in the dispatch office so he could be with me, and I said absolutely. He left before I did that day. When I got to work, there were beautiful flowers waiting for me from Cody on my desk. He had stopped at the corner and got them just for me to brighten my day. A little while later, he said he was going to leave for a while, and here he came with my favorite coffee from the human being. Later, he decided to take a break and returned with dinner for the two of us from Texas Roadhouse. By this point, I was wondering what he wanted or what had he done. He said, "Nothing, Mom. I just want you to know how much I love you and how special you are to me." There are no words to adequately describe a bond between a mother and her son. Cody and I shared such a close and unique bond that I will forever be broken, and I miss that relationship with him. I was so special to Cody, and he made sure I knew that every day. Cody always put me first and made sure, not just daily, but on special occasions, that if his dad and brother were working, he would pick up the slack and make sure his mama was taken care of. Whether it was flowers for Mother's Day or presents on Christmas, he had it covered. Cody would call me at least 10 times a day and shared everything with me. I was always his first call, good or bad. And he always started off with, "Guess what, Mama?" Some days it was to the point of, "Cody, I have to work. You are calling nonstop. Give me 5 minutes before you call me again." What I would give to have those days back and the guilt of not soaking it all in. Every time we would end our phone calls or parted ways, I would say, "I love you, Co." And he would always respond with, "I love you too, Mama." He wasn't afraid to express that in front of anyone, including his friends. The girls were so surprised that he would say that in front of everyone, and Cody would respond with, "Of course, I love my mama." I'm quite sure it earned him some brownie points with them too. I will never get to hear, "I love you, Mama," from my little boy ever again on this earth. Monday, October 9th, 2023 was and will be the worst day of my life. Cody left to go to school like any other day and had his week completely planned out. He had school, work, chores, working on his pickup, getting ready and sighting in his gun to go hunting, his homecoming bonfire, and most importantly, opening day of elk season on Sunday. All his homework was caught up and he was so excited to start the week. Unfortunately, he didn't even make it to school that day due to someone else's horrific choices. Instead, Laura from the Colorado State Patrol, who I have worked with for years, drove in my yard, and I knew it was bad. I begged her to tell me what hospital he was at and how important it was that I get to him because he needed me. The words that came out of her mouth cut to the bone. He was at the morgue. He was gone forever. A wave of panic came over me. That was impossible. I needed to get to my son. I died inside. My life as I knew it was over. It shattered. I can't explain the feeling of knowing that your child is at the morgue and there is nothing you can do to protect him or fix it. You failed as a parent. I could not process what she said or what that even meant. The days to follow are a blur, but I can tell you that the second worst day of my life was when I was asked at Adamson's if I would like to see my son for the last time. I struggled with that question. Do I remember him as he was, or do I say one final goodbye so I could give him a kiss and a hug and let him know I will see him again? My choice was to remember him the way he was, and the guilt and shame that has come with that decision will haunt me for the rest of my life. I feel as if I turned my back on him. I mean, really? Your own mom doesn't say goodbye? The next decision wasn't any easier. Would you like to bury your child or burn him? What do you say as a mom? How do you answer that? That was your child who you were supposed to protect. And here you are making these decisions. He was never supposed to leave me. I should never have had to make those decisions. Losing Cody has completely broken and shattered my world. Everything I knew or was is completely gone, including being a wife and a mother. Physically, the nightmares overpower the sleep medication, and the knot in my stomach overpowers the ability to eat, and even the simplest tasks are impossible. Emotionally, the consistent fear, anxiety, guilt, pain, panic, despair, and constant crying is so crippling, paralyzing, and all-consuming because Cody is not here. And what happened to him keeps replaying in my mind. I continue to try and fix it, but unfortunately, there is no fixing it for myself or my family. I am not able to see my son, talk to him, hug him, share special occasions with him, watch him in the next chapter of his life, see him daily, include him in our family or businesses, or even simply be a part of his life anymore. In fact, I have no idea what my son has been doing in heaven for the last 17 months. He has not been able to share that with me, and I feel so separated from him. He feels so far away, and with each passing day, I feel further and further away from him. It frustrates me to the point of, I'm done with this. It has gone on long enough. I just want my kid back. How can he not eventually come home? There is no way this is permanent. We have so much more to do and experience as a family and as individuals. However, the reality is that October 9th, 2023, we were given a life sentence, which is a punishment that we didn't deserve, nor did Cody. He saved someone's life. I was not ready to not be his mom on earth anymore. And because of that, every single day is a struggle. I can't even imagine what my son Cody endured in his final moments on this earth and the choices he was forced to make as a 17-year-old due solely to Mr. Mckee's actions. I can't imagine what he saw, what he felt, or what he went through, and I can't console him, protect him, comfort him, or fix it. I can't even talk to him. There is so much guilt I am experiencing, but the most difficult is that I wasn't there for him when he needed me the most, on the side of the road that day, and it is crushing. That day completely erased Cody's future. No senior pictures, graduations, holidays, birthdays, getting married, being an amazing father or an amazing uncle, a best man at his friend's wedding, his entrepreneurial business ideas, future hunting trips, goals, and I could go on, but in general, just plain life. Cody made a choice no 17-year-old should have to make that day. Cody made a choice no 17-year-old should have to make that day and avoided a head-on collision, and in true Cody fashion, he chose to save someone else's life in the devastation that followed, which meant that he would never be coming home. Never. Is Cody with Jesus? Yes. Will I be with Jesus? Yes. So will I see him again I will see him again someday. But unfortunately, that does nothing to ease the pain of not seeing him tonight, to ask him how his day went, or any other day until I see him again. That decision means that when I wake up in the morning, the first thing that I think is that was a horrible nightmare. But it is not a nightmare. It is my life, my reality, and so is the knot in the pit of my stomach. It means that the moment I open my door to leave my room in the morning, I am facing Cody's door to his room. It means that when I enter the bathroom, his toothbrush, toothpaste, comb, and hair gel sit on the counter waiting for him. It means that his clothes that he was going to wear for his senior pictures are still hanging in my laundry room, and his shoes and boots are still at the door. It means that all of his protein powder, workout shakes, and energy drinks are on the kitchen counter, and his place at the table is empty. It means that the parts he ordered for his pickup that were delivered 4 hours after he died have not been opened or put on yet. He was so excited for those parts and he didn't even get to see them. It means that his pickup is sitting in the driveway next to the window that my desk sits at. I see it all day long and it never moves. It means that there will never be another family picture with Cody in it. In fact, there has only been one taken since he was killed. It means that my cell phone will never light up with Cody calling or texting me. I will never on earth talk to him again. It means that when I make my Christmas list, one side is assigned to Caden and the other to Cody. Cody's will forever be blank. It means that our family will never be together on earth ever again. That is my everyday reality. How heavy is that? My house was noisy, messy, and straight chaos, balancing my kids, work, routines, deadlines, and life. We were so tight-knit that our lives intertwined in every aspect. I had such a unique bond with my boys, and I was the mom that cried when they had to go back to school. I never looked forward to it. I always wanted them with me. We were together at work, at home, and everywhere in between. There was never a dull moment, and it seemed as if life never let up to catch a breath. Somehow, though, we always ended up at home. That was our base, and I think subconsciously, that is one of the reasons I am truly glued to home. Eventually, in my mind, Cody will come home, back to our base. But now everything is different. The house is empty and quiet. Cody is gone, and the sting of losing Cody is too painful for Caden, and he rarely comes home. Everything else has gone by the wayside, and the pain and grief of losing Cody has changed everything. I have completely cut myself off from society. It is just too difficult to see other families lightheartedly shopping, talking about what they are having for dinner, planning birthday parties, or going out to eat. The reality is that I no longer shop for 4. I have an empty seat at the table. Birthday parties include balloons sent to heaven, and going to dinner is asking for a table for 3. There was a balance between Caden and Cody, and now there is no balance. How can I be a mom to a son in heaven and a mom to a son on earth? The answer is, I have no idea. Don't you have to do something to be a mom? Ask your kids how their day went, cook dinner, fold clothes, or help them with their problems? Anything I do for Caden, I can't do for Cody in that aspect. It makes me feel like I am betraying Cody. It feels as if Cody is excluded and left out of our lives, decisions, and future, which in turn makes me feel guilty about what I do for Caden. It has completely crippled me to the point of I am not a mom to either one. We operate several family businesses, so our lives are very untraditional, and both of the boys are huge parts of all aspects of our businesses. We, as a family of 4, operate them together. We made decisions together, made expansion plans together, and moved forward together. Our businesses have suffered tremendously, and I have not been present, and Joe has been with me. Our then 21-year-old stepped up and completely took over running our companies so that we didn't lose everything. That was a huge task for the 4 of us to accomplish. So you can imagine what kind of burden that would be for a 21-year-old. From running employees to taking care of customers to broke down machinery, it was a massive undertaking. Cody loved work and was going to operate a heavy wrecker for us. We purchased a heavy wrecker just for him, and he picked out the Bible verse on the side. I will fear no evil, for thou art with me, from the 23rd Psalm. His heavy wrecker also sits at home just outside my window. I have a long hallway to my office, and I can tell the difference between the sound of Joe, Caden, and Cody's boots coming down the hallway. Joe and Caden continue to use the hallway, but there are no more sounds from Cody's boots, just silence. Joe and Caden's uniforms are still getting delivered, but the pain of Cody's rack completely empty is heartbreaking. Throughout the trial, all of the actions and decisions that Cody made that day, that Jeff Kozad made that day, and that law enforcement made that day were all truth. Nothing was suppressed from the jury. However, Mr. Mckee was not held to the same standards. There were motions to suppress evidence and redact information to benefit the defendant. The defense attempted to confuse Jeff Kozad, but I would like the court to know that I did not listen to any of Jeff Kozad's testimony, and honestly, it was of no significance to me. The only action that mattered to me that day was that Jeff focused completely on my son, who was lying on the side of the road dying. He attempted to keep him alive and perform CPR for an unprecedented amount of time, all by himself. He didn't have to stop. He could have kept going. He didn't have to perform CPR. He could have waited for paramedics. He didn't have to continue CPR when he got tired, but he did. He didn't ask to be put into that situation, but he was, and he chose to try to save my son so that my son could come home to his family and have a future full of everything that he deserved. For that, I can never repay him, and thank you does nothing. How do you thank someone for trying to save your child's life? The answer is I can't. He is a true hero, a man of God. And to be honest, that was exactly who I wanted to be with my son that day. He didn't even know my family. But it is humbling to me that he planted himself into a situation that would forever change him, and that he too will carry with him for the rest of his life. But most importantly, he didn't leave Cody by himself. My main goal throughout this horrific court process that we have been dragged through has been not to let my son down, for him not to feel as if I have turned my back on him or abandoned him, but for him to know that as hard as it has been, I went through all of it for him. I am not leaving him. This has forced me to go to places I don't want to go to and dig up emotions that are brutal. I was the most important person to Cody, and I know it would completely devastate him to see me constantly crying or living like this. But there are so many things that were left unfinished and undone, and there is no closure. The damage is done, and I get to live with that for the rest of my life. I don't even want to go on. How can we go on when we are missing Cody? We always did everything as the four of us. To say there are numerous layers of pain is an understatement. It is humbling to know, however, how much Cody is loved and missed by so many people from so many communities and how important he is. The truck meets his friends organize, Cody's Closet to help kids in need at the school, Cody's Opportunity Fund to benefit the community, and the Colorado Division of Wildlife's Cody Hutchins Annual Hunt for Youth, to name a few, really show how loved and important he is and what a footprint he made in his short 17 years here on Earth. I have purposely tried not to include Mr. Mckee in this statement thus far so that he does not overshadow my family or my son, but the reality is that this was all caused by him. I would not be here today if he had made better decisions on October 9th, 2023. He has a history of making bad decisions, and this clearly shows that any consequences from prior offenses were not severe enough for Mr. Mckee to take the law seriously, and therefore, here we are. My family will suffer the ultimate consequences for the rest of our lives. Due to the severity of this crime, which is killing my 17-year-old son Cody as he was on his way to school and leaving him on the side of the road to die, Mr. Mckee turned his car around, determined it was appropriate to take a picture, not help, and then fled. This clearly shows Mr. McKee's choices and actions which exhibit complete disregard for human life and that he cares only about himself. Mr. Mckee has shown no emotion or remorse for his actions, which further shows that he does not acknowledge the severity of this crime, nor does he acknowledge that my 17-year-old son saved his life that day, but gave up his own. The amount of time Mr. Mckee is facing for his punishment for this crime is so insignificant compared to what he took away from my 17-year-old son, Cody, and my family, that I am asking you to send a clear message that this behavior will not be tolerated nor condoned, and the full sentence of 12 years for causing and leaving the scene of an accident, which he clearly did, should be served in the Department of Corrections. He has been able to manipulate the system in the past, which has contributed to his complete lack of accountability. And today, you can ensure that another family won't have to endure this pain for at least another 12 years. Thank you so much for your time, Your Honor.
All right, thank you, ma'am, for being here today. All right, Ms. Welsh, you may proceed.
That concludes the evidence from the state. The court wants to hear argument now, correct?
Yes, please, go ahead.
This court presided over the jury trial, so I'm not going to rehash through those facts, but ultimately the jury found the defendant guilty of failure to fulfill duties after involvement in an accident, which is a class 3 felony, and then the lesser included of the other felony, which was then careless driving causing death, a misdemeanor. That verdict came down on January 14th of 2025. But really, there's a statute that tells this court what to consider when determining the appropriate sentence. And so I'm going to walk through the factors that are highlighted in the Colorado Revised Statute 18-1-102.5. The seriousness of the offense, I don't think that I can truly state the seriousness of the offense here, but the family has done that justice. The loss of human life is the most serious offense committed in this country in its various forms. Ultimately, the legislature in Colorado has deemed operating a motor vehicle for this particular offense as a constitutionally permissible strict liability public welfare offense. And in passing the statute of failure to fulfill duties after involvement in the accident, the legislative intent was to advance the state's interest in promoting driver responsibility. Additionally, it was to minimize the harm that may result of a driver fleeing the scene of an accident and ensure social order by penalizing drivers who do not stop at accident scenes. Fair and consistent sentences. In prepping for this particular argument, I spent an extensive amount of time looking at convictions for failure to fulfill duties after involvement in an accident resulting in death throughout the entire state of Colorado. I predominantly looked at the 4 years leading up to COVID because COVID changed many things as it relates to sentencing. In the 4 years that led up to that, there were 54 convictions for failure to fulfill duties after involvement involving death, F3s, that resulted in convictions to those particular charges. In running those numbers, 77% of individuals were sentenced to the Department of Corrections. 1 individual went to community corrections. There were 8 sentences for probation. Only 3 of those resulted in probation with no further incarceration, which is what defense counsel was arguing for in the sentencing brief that was filed with this court. And looking at those 3 particular cases, one of which was ultimately revoked very quickly and then resentenced to the Department of Corrections. Another has an active warrant for her failure to comply with that.
Referring to the probation cases.
For the probation cases. So 1 went to DOC ultimately. The other one still has active warrants. Her whereabouts are unknown. And then the 3rd individual successfully completed probation and then immediately picked up new traffic charges that are now pending. In looking at Mr. McKee's individual circumstances, because it's unique for each and every individual, and that's something that the court needs to consider in looking at this, which I will highlight. I wanted to go through a few that I found that were particularly relevant for the factors that the court needs to consider. In Weld County Case 20 CR 1057, it's another case that I prosecuted. Ultimately, it started in front of a retired Honorable Judge Quammen and ultimately went through Judge Esser and then I believe was sentenced by Judge Hartman as a visiting judge at that point in that courtroom while Judge Esser was on leave. That defendant was sentenced to 10 years in the Department of Corrections after pleading guilty to that particular count. She struck a man that was on the side of the road with a flat tire and then fled that scene and was not detained for several days. Ultimately, that particular defendant had a TBI diagnosis at the time of this incident, which is akin to some of the mental health information that was provided from defense counsel to this court. At the time that she was sentenced, she had 1 prior successful deferred judgment and sentence that was sealed, again, similar to this defendant, so it's not applicable to be considered by the court for a sealed case. She had 1 prior traffic misdemeanor, similar to this defendant, and she did have 1 traffic case pending at the time of sentencing, and Mr. McKee did not at that time. Her LSI score was higher, but similar to the defendant, she did not meet eligibility requirements on the specific caseloads that probation factored in. There, the PSI writer, despite all the similarities between them, stable family environment, good education, high school diploma, work history, there, the PSI writer recommended Department of Corrections. Here, the PSI writer recommended probation. The only differences that I found between those was her pending traffic case and that her family had ultimately distanced themselves between her act and sentencing, in addition to her being female and Latino descendant. That's concerning when the PSI recommendation is completely different, when all of the other factors are the same. Another case that I ran across was 18 CR 2459, another Weld County case. This one again resulted in a 10-year Department of Corrections sentence. This was a 29-year-old male. His criminal history was limited to one prior traffic misdemeanor. He fled after the accident and was arrested several weeks later. Ultimately, he cooperated throughout that case and pled before going to trial. He left behind a 10-year-old daughter at that time. I bring this case to the court's attention because in that particular incident, he was drinking and driving, but he crossed through a road, and that the victim in that car was the passenger seat, the one that lost her life, and they were engaged in street racing. And I know that defense counsel is going to highlight that Mr. Hutchins was speeding according to the CDR data that came out at trial. And that's appropriate to highlight. He also didn't have his seatbelt on. Well, in this particular case in Weld County, the victim and her boyfriend were street racing at that time. And ultimately, the individual that struck that car, despite not engaging in street racing, but became an obstruction in their path, received a 10-year Department of Corrections sentence. There's 19 CR 1012, which is a Weld County case that you have honorably presided over, and ultimately he was sentenced to 10.5 years. At that time, that was a 26-year-old male. He hit a motorist on a motorcycle. He did not have an active driver's license at that time, and he was out on bond. But in looking at his criminal convictions at that time, he had 5 prior traffic offenses that were actual convictions, not just pending cases. I found Arapahoe case, 22 CR 1245, where a 20-year-old male turned himself in the day after the accident. So he contacted law enforcement while they were still actively looking for him. He had 3 prior traffic offenses that were infractions, not even misdemeanors, despite Mr. Mckee having misdemeanors. Given his age of 20 years old, we know that his frontal lobe wasn't fully developed, again, akin to the inability to necessarily think through similar things. He received a 7-year sentence in the Department of Corrections. I found Adams County cases and Larimer County cases with similarly situated male individuals that have been sentenced in the last 3 years since post-COVID, where they had either a minor in possession offense or very prior or minor traffic tickets, or no criminal history at all. And one received a 10-year Department of Corrections sentence. The most recent one I found was the Larimer case, 24 CR 65. That defendant had 0 criminal history and struck a pedestrian that was riding an electric scooter in the bike line, and ultimately was found a few weeks later. He was sentenced to 10 years in community corrections. That's the only community correction sentence that I looked at with a similarly situated individual.
And that was in Arapahoe County?
That was Larimer County, 24 CR 65. Deterrence, that's another factor that this court needs to look at. Not just as it relates to Mr. Mckee, but to the community generally, because these types of convictions are polarized in the media and prevalent. And sadly, accidents occur throughout our community daily. And certainly multiple deaths occur, fatalities occur throughout the year. Deterrence speaks to a Department of Corrections sentence. You can't take someone else's life if you're not driving on our same roadways, leaving them injured on the side of the road and ultimately to die without aid because of a failure to respond. In looking at individualized characteristics or correctional programs, which are 2 separate elements in the sentencing statute, I want to highlight a few things. The family and friends of Mr. Hutchins has talked about the defendant's extensive history. And the history they're referring to is his driving history, because that's what's relevant here. This was an act of driving. Starting in 2004, he received citations for too fast for conditions. He has multiple driving under restraint misdemeanor convictions in 2005, including spending 30 days of incarceration on an electronic home monitor. He received another following too closely in 2005 and a fictitious plates in 2018. In the fictitious plates case, he was ordered to do a safe driving course after he was involved in a single car accident where he had crashed his own car. He had an obstructed windshield, no proof of insurance, and got too close to oncoming traffic, swerved, overcorrected, and went off the road in Windsor. Notably, what's clear from the PSI is that the defendant doesn't have treatment needs. He's not struggling with a substance abuse disorder. He's not suffering from a mental health episode. He has his basic needs met. In fact, in all sense of purposes, he has stability in his life. He's a homeowner, he has a job, he has people that care about him, as evidenced in exhibits A through U that defense counsel submitted. But something's lacking that increases his criminal thinking and behaviors. And it's not just this autism spectrum disorder that is highlighted in the PSI and argued in defense counsel's sentencing brief. I want to talk about this particular offense and the choices that he made. He drove carelessly on his way to work. He chose to turn around and simply get out to snap a photo, send it to his girlfriend, which he admitted on the stand because he did choose to testify in this case. He drove away and went about his day. He made a lot of assumptions. He assumed that Mr. Kozad had the ability to call the police and that he was just an oil worker, that he was going to help Cody as he was on the side of the road. However, in all of his statements to law enforcement, because he made a lot of them, he said that he didn't have cell signal. So how can you assume that the other person has cell signal to call for help if he doesn't have any bars on his own cell phone just a few hundred yards away? He then claimed that he had a dead phone and no ability to charge it until he got to work, but we have his cell phone records and those were admitted at trial, and he was able to get onto Instagram and he was able to exchange messages with people. He told the law enforcement officers that he called his girlfriend when he got to work instead of calling the police, despite thinking about it at that point. In defense counsel's sentencing brief that was filed, he indicated that Mr. Mckee had the lowest level of mental compatibility in criminal law and that he responded to this incident from a position of logic. I think that the logical response isn't fully thought out because of the representations he made regarding his cell phone status. You can't assume that somebody else is trained in CPR. You can't assume that somebody has the ability to call 911 or even has their cell phone with them that's charged and has signal when you don't yourself. This wasn't a mistake of fact. This is black and white law, which is why it's a strict liability offense. And a lot of the argument in that sentencing argument was talking about his ability to understand the law, misinterpretation of the facts. The law doesn't change just because of someone's individual circumstances as it relates to this particular offense. What this really comes down to is what the defendant told law enforcement in his own words. He didn't want to clean up effing dead bodies, and he didn't want to go home and have nightmares and have to do therapy for all of this, and then he used the S word. Those were his statements to law enforcement about why he didn't stop. It wasn't necessarily just because he didn't want to, or he didn't have cell signal. In fact, he knew it was recommended because that's what he told law enforcement officers on their body-worn camera, that it was recommended and he elected not to. In addition to snapping pictures and leaving the scene, he drove his other vehicle the following day when law enforcement was out patrolling, trying to find the white car that was involved in the incident. He also changed his version of events when confronted with his inconsistencies on body-worn camera that was admitted to this court. He scratched out his prior written statement and representations to law enforcement and modified his version of events to, I had a dead phone, to I didn't have cell signal. I want to point out a few things in the PSI and specifically in Defense Exhibit U. I spoke to the probation officer, Carrie Walker, yesterday as I had questions, because in the education section, it talks about the defendant's diagnosis for the autism spectrum disorder and dyslexia and special education experience. But it also notes that he was able to graduate high school with his diploma. In the recommendation section, she specifically put that the defendant, due to his neurological and developmental disabilities, appears to have difficulty understanding societal norms, and as evidenced in this case, is challenged in knowing how to apply moral reasoning in high-stress circumstances. When I asked her about that, I asked if she received any documentation that had a designated diagnosis for the autism spectrum disorder, and she indicated that the PSI is 100% based upon what the defendant told her. It's based upon how he presented himself during the interview and what he self-reported. She also highlighted that as a PSI writer, she's not qualified to make any sort of medical diagnosis. This is important because when I asked about verifying with school records or a medical diagnosis, the answer was, I received no documentation for these things. She did note that he presented as someone who didn't understand social norms when she did her face-to-face interview. In Defendant's Exhibit U, he was diagnosed with ADHD and learning disabilities in reading, written expression, and mathematics. And that particular medical professional rule out autism spectrum disorder. That is not a diagnosis for that particular disease. In fact, in the evaluation, it said the need for further ADS or ASD testing and suggested that he should pursue a formal evaluation for that particular disorder. This is not a diagnosis. It was ruled out in this particular testing because this particular medical professional is not the expert in the autism spectrum disorder. And so that's a misrepresentation based upon that particular evaluation. As it relates to restoration for victims and community, as noted on the record, the victim's family and his community have certainly taken steps to restore and hold in memory Cody Hutchins' life. But there's nothing that the defendant can do to bring that 17-year-old back to his loved ones and his community, and their lives are changed forever. And the sentiment shared by Mr. Kozad, ensuring that no other families have to experience a similar devastating loss and in similar circumstances is the best way to repair our community so that they don't suffer a further loss. In conclusion, I would like to highlight that the crime and severity are aggravated. His particular response to this situation was aggravated. The effect on the victim was aggravated. His criminal history, as it relates to traffic offenses, is aggravated when compared with the 5 other similarly situated individuals that committed the same offense. His individual characteristics don't justify a treatment-based approach. What is community corrections going to treat with him, even though they accepted him? And what is a supervised probation sentence going to do when he's already taken safe driving classes and he's not experiencing a substance abuse disorder or a mental health disorder? And in fact, what deterrence is there left in a community-based sentence? All other similarly situated individuals facing bad driving on behalf of the other participant facing same or similar mental health abilities were sentenced to the Department of Corrections that I found and highlighted for this court. And I'm asking that the court sentence the defendant consistent with other similarly situated individuals to a Department of Corrections sentence on the F3 count and a concurrent jail sentence on the careless driving resulting in death count. Thank you.
All right, thank you, Ms. Wells. Mr. Estel, if you have any sentencing witnesses, go ahead and proceed.
Your Honor, if you don't mind, would you mind if I kind of do my argument first so that they're not tempted to kind of respond to the argument and their statements, and then they can just focus on speaking about Mr. McKee after I...
In whatever order you wish to proceed.
All right,
Go ahead.
thank you. Judge, I've been doing this work almost 20 years, and trials are a wonderful thing. I think they're great for many, many things. However, they are not great for other things, and they are sometimes necessary. They are often unsatisfying in what they tell us about what happened in a particular case. The verdict in this case asked the jury a very narrow question. It asked, was Mr. McKee involved in this accident? And they came back and said that he was at the absolute lowest level. They found him guilty of a careless or an imprudent act in terms of his driving. That doesn't tell us a lot from the jury's verdict about where they thought his car was on the road or how much causality he had, because there was this is not a civil case where comparative negligence was at stake, and they weren't asked to say how responsible was Mr. McKee versus the level of responsibility of the other driver. If he was even 1% responsible, then he was guilty under this criminal law. And so it's a very narrow question, and I think it's important because the narrowness of that question speaks to the narrowness of your role in what we should be considering when we think about sentencing in this case. There is absolutely no doubt that this was a tragedy and that the loss suffered by the Hutchins family and friends who have spoken here today is absolutely immense. Nobody questions that. We don't question that, never have. And it appears from everything I've heard today and from the beginning of this case that Cody Hutchins was a fantastic kid. It was said on the body-worn camera by one of the first responders who knew him, that he was a good kid, a great kid. And the reality here is there's nothing about his decisions, the speed he was driving, the not wearing seatbelt, there's nothing about his decisions that day that take away from the fact that he was a great kid and that his community and his family has suffered a great loss. The same is true in many ways of Mr. Mckee. He's a very different person than Cody. I listened to the descriptions here of Mr. Hutchins, and he just sounds larger than life. Many people talked about him having a big personality. Mr. Mckee is the opposite. He's a smaller than life person. He is not comfortable being the extrovert, interacting with people. He's constructed his life to live alone with his service dog and his family that he sees sometimes but doesn't live with. He lives alone. But when you read the letters that we submitted, what you hear over and over and over again is that he's kind, that he was helpful. And in many of the same things you heard about Mr. Hutchins, you will read and hear a little bit about Mr. Mckee, that he would hang out with his nieces and nephews. He would do projects for people around their house when something needed done. He is a kind person. He was loved by maybe a smaller circle, but he was a kind and helpful person. And it was really hard. I made a list of all the times here that people said that he was the sole cause of this accident. And I get it. I get the loss. I get the grief. I get the impetus to blame 100% Mr. Mckee for what happened on that road that day. But those aren't the facts. The jury found him not guilty of reckless driving. They found that he was not reckless that day. And I take that and I argue to the court that that means he was not driving in the wrong side of the road. He may not have been as far over as he thought, and he accepts that that's the jury's verdict. But it wasn't being reckless. And I'll remind the court that the testimony during the trial from the trooper was that Mr. Hutchins was being reckless. He had a level of contribution that day. And I don't say that to take away from the loss of his family in the slightest. But when the court stands between two aggrieved parties, and it's an unfortunate aspect of our system that when we come to court and the people have to exercise their rights and argue their case, it sets up an oppositional position between the two families, between the two parties. And it's natural that they would think the worst of Mr. Mckee because he said, I didn't think I was involved. I didn't think I had to stay. And they absolutely see the worst in him. And I get it. They're entitled to do that. But they repeatedly said he's shown no remorse, taken no responsibility, no accountability. And part of that's due to the nature of our system. Part of that's due to the fact that he was not 100% at fault in this case. There's been no recognition of the fact that Mr. Hutchins' actions, his speed, contributed. And I would argue were the primary contributor if he was being reckless and Mr. Mckee was only careless or imprudent. Ms. Wells talked about the purposes of sentencing. I went through that some in my brief. And she talked about the other cases. And what I noted about all the cases that she mentioned, and I went through some of this in my brief, is that this law, the felony law here, the one we're really talking about in terms of a long sentence, it's designed for those cases where there's a clear at-fault person who knew, it was clear they should have known, and left the scene. Everything she talked about involved people who were under the influence, people who struck pedestrians or bystanders. People, the only one she mentioned where the victim party was somewhat at fault, then they were street racing. And in that case, those people were also, or that defendant was found to be drinking and driving, which gets to the vehicular homicide level of an offense or a vehicular assault. None of that's true in this case. In this case, we didn't have a collision. You know, I talked about in the brief, the colloquial version of this crime is known as a hit and run. And there was no hit here because there was no collision. It was not clear that Mr. Mckee was involved. We had a very long trial with a lot of contested evidence, and the jury ultimately found that he was involved at this careless or imprudent level. And he accepts that. But it doesn't change the fact that on that day, in that moment, he didn't know that's what the jury verdict was going to be. He didn't think he was involved. And he didn't think that he was legally required to stay. But he did. As he sat at the top of the hill where he couldn't see what was going on, and he thought, I'm lucky that I am alive. I'm lucky that this driver didn't hit me. I don't think I'm required to stay and do anything, but I should. And he turned around, and what I've heard throughout this case is that when he saw that Mr. Kozad was there, his response was one of relief. And I think that really speaks to who Scott is as a person and to how his ASD and his autism impacts his brain. He knew that he needed to check. And he did, but once he knew that somebody else was there and taking that on, he felt relief that he, not being involved, not being the closest one, could leave. And throughout this case, he's learned afterwards, being arrested, being charged, going to trial. In retrospect, he's been able to see, man, I should have stayed. I should have gone down to try and help Mr. Kozad. That's what society expects. And I think the PSI writer really got it right. And I know she only meets with Scott for a short time, and I didn't send her anything. I didn't send her his evaluations or anything else. She met him and she was able to tell from the way he presented and what he told her that he struggles to understand societal expectations, social interactions, executive functioning. And she really nailed it in the pre-sentence report. I will note I did submit a partial eval that he did. The real diagnosis of autism came when he was young, and that was part of his school records, and he was formally diagnosed with autism. He hasn't needed to be diagnosed for his career as a woodworker or anything else in his life. So this more recent evaluation looked at that and said, if he needed a formal diagnosis, for instance, to apply for disability, which they recommended, or something like that, he could have followed up with a more formal diagnosis, but he doesn't need that, and he didn't do that. That's not an attempt to mislead. That's just the reality of when he was in school, he needed the formal diagnosis. More recently, he didn't need to go to that level. I was struck by something, I think it was Pastor Pembroke. He said, Cody wasn't perfect, but he was amazing. And I've talked with Scott's family and gotten to know them. I've known Scott for a number of years. And Scott's not perfect either. But he is amazing. He's amazing in his own way. But he's an amazing guy. And the biggest thing that I've seen from him, and I think it speaks to his actions and reactions on that day, is that he's content in every circumstance. He is not subject to big emotions. I haven't seen him get angry at this case, at being arrested and charged and facing these sentences. I haven't seen him get sad, which a lot of people held against him for not showing remorse. Even when he was taken into custody following the trial and I went and saw him, his ability to accept life as it comes and say, okay, I did the best I could. I thought I was right. The jury said I was wrong. Okay, I accept that. Throughout this case, throughout this process, throughout this trial, that's what I've seen in Scott. And he understands the level of emotion and blame that has been directed his way. And he accepts it. He takes it. He says, I get it. I thought I was right. I thought I wasn't involved. There was no collision. Someone else was taking care of him. He went through that process and thought, I don't think I have to stay here. And then a jury told him he was wrong. And he accepts that. But as the court looks at sentencing, it's important to remember that on causality, on causing this accident and on causing this death, Mr. Mckee was only found guilty of careless driving, of driving in an imprudent manner. It's a very low level of culpability in our system. We send people to DOC when they act after deliberation, with intent, when they act knowingly. We call those crimes homicides or murders. We don't tend to send people, we can't send people to prison for negligence, for careless or imprudence. Those cases are mostly handled in the civil courts, where only money is at stake. That's what the court, when they look at the purposes of sentencing, should be looking at is what is the level of punishment that is relative to the level of culpability for Mr. Mckee. And the court's already done that by taking him into custody. He served 58 days so far. In my review of cases I've been involved with over the last 20 years, for most cases of careless causing death, a large amount of community service is the most common sentence that I've seen. It's usually not even a 60-day jail sentence. It's usually community service. And this F3, I think, is particularly unique. This is not a case where he struck an innocent party and it's clear that he's at fault and they're the 100% the victim. It's not a case that involved drinking and driving. It was not a case where he hit another cyclist, a motorcyclist, and was clearly at fault. All of those other cases involved a collision. And from what I can tell, a collision where it was very clear one party was at fault and the other party was the victim. Not a non-collision with shared liability and shared culpability. That's what makes this case different. Frankly, I think that's why this case had to go to trial, is because the decision in this unique of a circumstance, was I involved in this crash, was not obvious. And because it was not obvious, he shouldn't be punished as if it was. And he knew and should have known and fled the way it might have been in some of these other cases. He had some criminal history. It's not major. It's 20 years old. That involved him with a couple of traffic infractions and then him not having a license a few times. He handled all of that. As I indicated, the most recent one that's on his record, that SEAL case didn't involve him at all. That was his brother, and I just helped him get that taken care of. There's a lot of assumptions that have been made about Mr. Mckee and who he is. The word wicked was thrown around. The claim that he is the sole person who is responsible for this. You're going to hear after I'm done from some members of his family, they're going to help tell you what I put in that sentencing brief. That's not who Mr. Mckee is. He is a kind person. He is a helpful person. He is a person with autism who struggles, but has created a space for himself in this life and this community that works for him. In these few seconds are explained. His decisions there are explained by that version of him. He doesn't have to be a wicked, evil, horrible person in order to have been in a really tough situation. And to have thought that he was right, to have thought that he did the right thing, and he obeyed the law, and that he had no obligation, and to have been wrong about that. When I read his review, his psych eval, and I read about his academic struggles, and I thought about my conversations with Scott, I just thought that when Ms. Wells and I talk about this case, when we argue the law and the way the facts apply to the jury in so many ways, this tragedy, the legal aspect of it, was a very academic exercise. What does the word involved mean? How far over on the road was each car? How fast were they? What was the visibility? It was like a complicated academic problem that we all struggled, and a jury gave us an answer. And I don't know exactly what that answer means, but Mr. Mckee shouldn't be punished, not with 12 years in prison, for not getting that right in the heat of the moment, with his heart pounding at the top of the hill. Thought he did the right thing. He accepts that he was wrong. He accepts the 58 days that he's done. The PSI recommended some therapy to help him better understand. He's willing to do that, more than happy to do it. But in terms of punishing him for a level of culpability, it's not there. His level of culpability for causation, very, very low. And in terms of the leaving the scene, he shouldn't be punished as if he was recklessly causing, as if he had been found guilty of vehicular homicide. He shouldn't be punished for a vehicular homicide he was acquitted of under the rubric of a leaving the scene. The causation should reflect the level of causation, and given the totally unique and academic aspects of the leaving the scene, the recommendations of the PSI are appropriate. I'll hear from a few members of his family.
All right, thank you, Mr. Essel. Go ahead.
First up will be his sister, Stephanie Meza.
All right.
M-E-Z-A.
All right, thank you. Ma'am, if you can please come forward. And again, if you could please state your full name and just spell your last name for the record, and then I'm happy to consider anything that you'd like to tell me.
Okay, thanks. Stephanie Meza, and then last name M-E-Z-A.
All right, go ahead, ma'am.
Okay, my name is Stephanie Meza. I am the older sister of Scott Timothy Mckee. First off, I want to start out by giving my condolences to the family. Losing a child is true hell. No family should ever have to be in. 9 days after Cody passed, we lost our oldest son in a tragic car accident. I pray for your family. I pray for our family, and I pray we all find peace and comfort in the loss of our beloved children. I know Scott has been made out to be a monster of some sort, but he's not anywhere close to that. My brother Scott is a different kind of human. He has a disability. He was nonverbal until the age of 6. I helped raise this little guy, and I find comfort and peace that I know I did a good job. Autistic people don't handle situations the way a normal person would handle something. I truly believe in my heart and my soul that my little brother did not even think he was involved in an accident, and that he couldn't comprehend what was going on during. He should have never left the scene. We all know that. But he didn't have the mental capacity to understand why. Anyone and everyone who knows in any way can vow Scott is a loving, kind human being. He would do absolutely anything for anybody at any time. Speed, seatbelts, a lack of airbags, a dirt road are all huge factors in this accident. I ask that you give my brother a fair chance at life, since we all know that every day is not to be promised. Scott has overcome so much in his lifetime. He's much more to continue to offer to his service, his dogs, his nieces, and his nephews into this world. And I thank you for your time.
All right, thank you, Ms. Mason. All right, Mr. Estel, go ahead. Thank you, sir. If you'll come forward. And sir, if you'll please state your full name and spell your last name for the record, and then I'm happy to consider anything that you'd like to tell me.
My name is Dr. Stephen Martin, Martin.
All right, thank you, sir. Go ahead.
First thing I'd like to address today is the tragedy that brings us together. My sympathy, empathy, and heartbreak goes out to all the friends and family of Cody. I completely understand and know the devastation of what it's like to lose a loved one. On October 23rd, 2023, my son died in a car accident. He was just 6 weeks from graduating from law school. Please know that I wish for solace and comfort for all of us as we grieve. Secondly, I'd like to address what I know about Scott Mckee. I've known Scott for over a decade, both socially and as a patient. I know Scott to be hardworking, amazing with his hands, caring for others and for animals, especially his dog Lola. I've also known Scott to be socially awkward and shy. Having witnessed Scott being arrested outside of my office, I could see the concern and confusion on his face and his lack of ability to completely understand the situation as perhaps a normal person would. Lastly, I hope that this tragedy doesn't end up ruining two families, and that all of us involved can eventually find the ability to deal with this situation and to be able to find some peace, just as I'm searching for. Thank you, Judge.
All right, thank you, Doctor. All right, Mr. Estel, go ahead.
I don't think anyone else is going to speak, and I've spoken with Mr. Mckee, and the court read his statements in the PSI, which I think sum up what he can say about this and what he has said about this. You've heard a lot over the last couple of hours, and what he told me was, I think everything's been said. He has an amazing, as you heard, this family has experienced loss. He has sympathy and empathy for what the Hudgens family has gone through. He feels like he's learned a lot through this himself as a person, dealing with being charged with this and going through this process. And as he and I talked in the jail, just preparing, I think we came to this place where he wanted to convey to the court. He did the best he could. He understands now it wasn't enough. And he accepts what the court has for him.
All right, thank you, Mr. Estel. And Mr. Estel, I just need to confirm with Mr. Mckee directly. Mr. Mckee, is there anything that you would like to tell me before I impose sentence in this case? You don't have to if you don't want to, and I won't hold it against you if you choose not to speak.
No, I feel like everything's been said.
All right, thank you, Mr. McKee. So, Mr. McKee, we're here today to deal with the consequences of your actions, nothing more and nothing less than that. Before I deal with what this sentencing hearing is about, I need to make sure that I acknowledge what the sentencing hearing is not about. So you were convicted of a Class 3 felony, leaving the scene of an accident causing death. That has always been the most serious case, most serious charge that you've been charged with, and you were convicted of the most serious charge that you've been charged with. I'm not here to determine what level you should be charged with. I'm not here to determine what that offense consists of. Throughout this case, it seems to me there's been sort of a conflation between who caused the accident and that portion of the charge regarding leaving the scene of the accident. And I want to make sure that you understand those are two separate and distinct things. The jury convicted you not of reckless behavior, but of careless behavior regarding your actions causing the accident itself. But the leaving the scene of the accident does not take into consideration whether you are acting knowingly, recklessly, intentionally, or anything like that. It is a strict liability crime. The fact of the matter is that when you choose to drive in the state of Colorado, that comes with a lot of responsibility. And part of that responsibility is knowing what your obligations are as a driver. And the legislature of the state of Colorado has chosen to acknowledge that when you don't follow that responsibility in terms of an accident where someone loses their life, then the punishment for that is very severe. And that is primarily the issue that I'm confronted with today. I want to talk about the legal consequences of your actions, but first I want to make sure that I acknowledge all of the other consequences of your actions. You've heard a lot of people today talk about the pain, the immense pain that they've suffered because of the loss of Cody Hutchins. Now, it is a blessing anytime that you are lucky to have a bright light in your life by the way of a child. And it is even more tragic when that light gets taken away from you and you have to live in the darkness of that. And you've heard a lot of people talk about the darkness of that. Wherever this happens in the world, wherever a family loses a child, it's horrible. All of the things that a parent should be able to experience, like watching your son become a man, watching him have his own family, watching him make his way through the world, and watching that 4-year-old kid who used to run around your yard become a person that you can be proud of when you see him as he goes through his life. One of the things that I need to make sure that I acknowledge about the consequences of your actions, because I understand this, is, as I've stated, wherever this happens in the world is horrible and tragic and inconceivably sad. But I will tell you, I always tell people when I'm doing my job, I want to give justice for the community because I grew up here. I've lived in this county my whole life. I was born in a hospital just about a mile away. And I, like many people in this courtroom, and maybe even including you and your family, had County Road as part of my address when I grew up. As I've stated, this is horrible wherever it happens in the world, but when a tragedy happens in a small community, the pain is that much more difficult to deal with. And I want to give you an example. I heard from a pastor who's also married to the kindergarten teacher. I heard from a veterinarian who's also on the school board. I've heard from a bus driver who also cooks food for the kids. When you are in a small community, the thread of your existence is so inextricably woven with the other threads of that community that when one thread gets frayed or snapped, everyone feels it. Everyone feels it. And so if something like this happened in Greeley, maybe I could go to a random house and knock on the door and ask those people, oh, did you hear about this thing that happened? And they might say no. They might say, I've never heard of that child. I don't know that family. I don't know what happened. The people of this small community don't have that privilege. I imagine whatever door I knocked on surrounding Grover and I asked about Cody Hutchinson, I bet every single person would say, yes, I know what happened. And it hurts. It hurts and I'm sad. And I want to make sure that I acknowledge that because I know what it's like to come from a small community. And I know that there is a unique sort of hurt that this family, that these neighbors, that these friends, that these students are going through that is maybe different than if this had happened in a large community. So, Mr. McKee, it is those consequences that I have to acknowledge through your legal consequences. Now, there's also things here that I agree are unique. So I've heard information regarding your mental status, and I'm also well versed about neurodivergence and the various ways that can express itself and the inhibitions, the barriers that can put up for an individual. And for what it's worth, I don't have any doubt that you are on that spectrum, that you are neurodivergent, and that's caused you some barriers in life. However, I want to make sure that you understand, while those are factors that I need to consider, it's not a free pass. It's not an excuse. It's not something that eliminates the consequences of your actions. Just as if my eyesight gets worse and worse and worse, at some point, I shouldn't be behind the wheel of a car, because even though it's not something I can control, even though it's not something that it's my fault, it's just sort of the natural progression of things. Eventually, it may get to the point where I can't put other people in danger and I can't fulfill the responsibilities that the state of Colorado says that I need to have if I get behind the wheel of a car. If your neurodivergence means that you don't understand the responsibilities of what you need to do as a driver in the state of Colorado, then that probably means that you shouldn't be driving. Just like any other disability, you have to operate at a minimum level to be able to be behind the wheel of a vehicle that can tremendously harm someone. Because when you get behind the wheel of a car, it ceases to be just about you. You're no longer the main character of your story, because there are other people on the road. There are other people going about their lives. And when something bad happens, it's tragic and it's horrible and it's sad. It's inconceivably sad. Mr. McKee, I will be frank with you. I agree with the family when they've talked about how, one of the very first people that talked about how, sort of conversations about probation and parole seem paltry when we consider this loss. And I agree that probation is not an appropriate sentence in this case. Because again, regardless of what brought you before the court, in the context of what happened surrounding this circumstance, the fact remains that part of these consequences have been an inconceivably tragic loss, and I need to acknowledge that in the sentence. Mr. McKee, I think, had these been different circumstances regarding your personal situation, your neurodivergence, it would be hard pressed for me not to imagine sending you to prison. But I appreciate that all of us are made in different ways, and that your level of moral culpability, if not your level of legal culpability, may be slightly different. Now, that doesn't mean that there isn't going to be a severe outcome out of all of this. But I believe that that means that there are other outcomes that I can do to give you an opportunity to demonstrate to me and to demonstrate to everybody in this room that you should not be defined by the absolute worst mistake that you've ever made in your life, because it's hard for me to imagine you making a worse mistake than the one that you did on this day. The reason that we have this offense, the reason why this offense is so severe, I hope, is because the law acknowledges that even if you didn't cause an accident, even if you were only involved in an accident, you have an obligation to stay. You have an obligation to stay there, to get everything sorted out, exchange information, interact with the police, let them take down, let them do their job. So then they can figure out, was it your fault? Was it their fault? Was it nobody's fault? Was it just a thing that happened? So everybody can do the things that they need to do to resolve the situation. When encompassed in that, a young man dies, there's also a dignity aspect of it. Because you were involved in a situation, whether you caused it or not, you were involved in a situation where a young man died, and the dignity of his existence demanded that you stay there while things got sorted out. I imagine if you did stay there, who knows how this would have progressed. I would imagine if you did stay there, I'm not even sure that you would have been in trial in front of me when all of this was all said and done. You know, maybe we're just talking about misdemeanors. Maybe we're talking about a different situation. Maybe we're talking about a resolvable situation. Who knows? But it is that choice that is the most severe that you made in here that I need to acknowledge. Because Cody deserved better. Even if you were involved in it and it was 100% his fault, which clearly the jury did not believe that that was the case. But even if it was, you owed him that much. Because regardless of who was driving and what was happening, we all deserve a certain amount of dignity as human beings, and we all deserve a certain amount of dignity when we pass in tragic circumstances. So with that being said, Mr. Mckee, I'm going to give you an opportunity, and only one opportunity, to remain in the community. I am thankful that you were accepted into community corrections, because I think that it is a severe punishment. It is a severe punishment that I can make lengthy, but also at least gives you an opportunity here to demonstrate that this is not a situation that you should define you going forward. What I am going to do, Mr. Mckee, I am going to sentence you to 12 years in community corrections. Part of the consideration that I'm considering with community corrections is that you will remain in custody until transferred into the community corrections facility. The second consideration that I'm doing community corrections is because I am aware of the restriction that they will have on driving, and that you will not be able to drive while you're at the community corrections facility. The third reason that I am sending you to community corrections, because I am aware, because that happens all the time in my job, that if you choose not to take it seriously, that if you choose not to do the many things that I expect that they will make you do over there in terms of therapy and treatment and classes and community service and their expectations with you working and all of the other things that are going to be a part of that sentence, that you will be taken back into custody, that I will receive a motion to transfer your sentence to the Department of Corrections. And then that will be just what happens. Like, you will just be going to the Department of Corrections. I want to make sure that you understand that if you go there, you do not take this seriously, and you fail, that sentencing hearing is not going to look like this. It's going to be very brief. It's going to be mostly involving paperwork. And I will just be considering about granting the motion to transfer, counting up however many days that you served, and then they'll take you to the Department of Corrections. Mr. McKee, I hope you take advantage of this one and only opportunity that you have here. Because regardless of your personal circumstances, if you come back before me, that is what's going to happen. You owe this family a lot, an inconceivable amount. And you're going to choose whether or not you acknowledge the loss here by your actions going forward. I genuinely hope that you do. Because there's nothing that I can say or do to alleviate the pain that this family and this community has gone through. But you can do something by your actions to show at the very least that you acknowledge it. So, Mr. McKee, I hope you consider that going forward here. I should note as to the Class 3 felony that you do have 58 days credit for time served against that sentence. Regarding the Class 1 traffic infraction, I am going to sentence you to 58 days in the Weld County Jail and give you credit for the time that you have already served. So that sentence will naturally be subsumed into your more severe sentence. Mr. McKee, I do want to wish you good luck, sir. I hope that you've listened to what I've told you today and you take advantage of this singular opportunity. It will be a shame if I see you before the court again. To the family and community members here, I know that this has been tremendously painful, tremendously difficult for you all as a community. I hope that I don't have to see you all in the future because of Mr. McKee's actions during this sentence. But if I do, I hope that you can be confident that you will know what happened as a result of those actions. So with that, that will be the order of the court. Mr. McKee, you will be remanded into custody. Please cooperate with the deputies as they take you into custody. And the court will be in a brief recess until we resume on the Rodriguez matter. And I'm sorry, Ms. Wells, I presume that you are asking about restitution.
Yes, Your
Let me
Honor.
pull up this pending motion.
For the record, we thought the $10,000 that crime victim comp is out of pocket for celebration of life expenses and then ongoing reservation of mental health treatment for the direct family that has been approved for funding through CVC.
I am going to order as a condition of your sentence that you will be liable for the payment of restitution in the amount of $10,000 payable to the Crime Victim Compensation Fund as indicated in the state's motion that they filed today. That order will be pending in a future request for a hearing. I am going to give your attorney 45 days to file any request for a hearing. And if one is filed, we will schedule a hearing no later than 91 days from today's date.
I can tell you, Judge, we were already familiar with that amount from pretrial things, and we're not going to have an objection. to that.
Okay, given that you have no objection, I'll go ahead and enter that order today. All right, thank you. All right. And Ms. Wells, before we go off the record, was that what you needed to mention?
Yes, Your Honor.
Okay, thank you.
Call me as soon as you can.
All right, so it's been a crazy morning. Court is gonna go on a short break, so I think it was too lenient. I agree with you all. I think absolutely Lola, Trevor, everyone in chat. I agree with you 100% that you absolutely went too lenient. true, we did not see this trial, sadly, but we heard the matters of the fact and everything. But I think he was just too lenient, and I do not agree at all with him. But anyway, right now we are going to portal to the new stream. It is already set up. I'm already almost there, literally, as well. So I am going to do the redirect now, and then I'll see you all, because we are going to get ready sorry, for the closing statements and verdict watch for Stacey Rodriguez. I hope to see you all there very, very shortly. Thank you very much for the support, and you guys are amazing. I'll see you very, very shortly, everybody.
And I'm a real-time crime professional.